Good morning, good morning, good morning, amazing. Leonard, we are back together again. And I didn't know if we were going to be together again in this way, but I thought that we might be. We're talking about Alec Murdaugh today. It's Thursday, it's May 14th. Let me know where you're coming in from, what you're drinking, because the murdacity, and really, truly, this isn't the murdacity from Murdaugh. This is the courthouse Becky of it all. So today I got a full pint of coffee ready to go. We are going to be talking about what the South Carolina Supreme Court ruled and why. It is a very good opportunity for us to take a look at an appeals court where they overturned a trial, overturned a conviction, and why. And we have some words from the South Carolina Attorney General, Alan Wilson, because he had some thoughts. If you guys haven't seen that yet, we're going to cover that together. If you have seen it, no spoilers, you're the best. And of course, if there's a camera, there's a poot. So we're going to talk about poot as well. We're going to talk about poot as well. I've got thoughts. You've got thoughts. We've got thoughts. We're going to go over this entire, maybe less a few lines. We're going to go through this entire opinion together. It's 27 pages long. It's not the lengthiest opinion, but, well, the ruling is pretty clear, and I love that the South Carolina Supreme Court actually puts a little snippet of what their holding is, what their finding is, what their ruling is, because it's really helpful to just be like, oh, cut to the point. You get a new trial. You get a new trial. Courthouse Becky. What did you do, girl? Well, I guess we already know what she did because we saw all of the hearings. We saw her lie to Justice Toll. We saw her prosecuted, not for jury tampering, but everything else, I think. We saw her sentenced to probation and hurt feelings. And now we're going to see the taxpayers of South Carolina spend millions more on another trial. Thanks, Becky. Let's get going. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I can see in the chat. Hello, chat. It's always good to see you. Anyone exhausted after yesterday? I'm exhausted after yesterday. If the Murdaugh trial was not a trial that you were deeply invested in, if you were not embedded in the Murdaugh trial, I understand. Poot is the defense attorney, Dick Harpootlian, nicknamed Poot. We had a member in chat who was sharing that their parent had gone to university with Poot, and that was in fact his nickname. We had given him that nickname because his last name is Harpootlian. Poot. Courthouse Becky being Courthouse Becky, we do have some nicknames. We are going to have a new judge this retrial because the judge that we very much loved, the judge that taught us to
bring the jury,
has retired. So new judge, new jury, same prosecutor, same defense team. Maybe new venue. Maybe they're going to move it to Charleston, not Charlotte, because South Carolina. Maybe they're going to move it to Charleston. We're just going to have to wait and see. But I imagine we're going to see a flurry of legal filings. And we're going to see, I imagine, a request for change of venue. That actually might have a chance on a retrial because it is a smaller county. And a lot of people know this case and the fallout from this case. That said, well, the juries were found in other high-profile cases, other cases of regional interest. I do think we might see them moving this case. I think that is a possibility, but we knew that this was a possibility too, even though we don't love it. And that happens, right? We watch these cases, we go through what happens, and sometimes the results are not what we were thinking. Though I will say when it comes to this result, I did think that this is where we would end up. Once we got to the arguments, took a look at how some of this standard plays out elsewhere, I did think we would end up with this result. I was not particularly surprised when the court decided, hey, we're going to go ahead and overturn that. I was not shocked by that result. It's frustrating for sure. It's going to be expensive. It is going to be time consuming. It is going to be all the things. But what it's not really is a surprise. Is anybody surprised, like shocked, flabbergasted, jaw on the floor? Or is everybody's like, I kind of thought they were going to do that. I kind of hope they wouldn't do that, but I kind of thought they were going to do that. Because once you look at what the standard is and what Courthouse Becky did, it's really hard to come to any other conclusion. And the defendant's right to a fair trial in this case is based on interference from an elected official. And that interference, they argued and proved, did, overrode the right to a fair trial for Alec Murdaugh. He has the right to a fair trial. And when you hear judges talk about we need to protect the conviction, in the future, remember this case. Because as judges talk about protecting a conviction, as I talk about protecting a conviction, judges don't say that expressly. They rule that way. This is what we're talking about. We're talking about not ending up back here. This is not where anybody wants to be. Retrials are hard. Retrials are not unknown to the law. Retrials happen after hung juries all the time. Retrials don't always happen after appeal. Alec Murdaugh was convicted in 2023, March 2023, more than 3 years ago. All things considered, though, on appeal, this happened pretty fast. This did happen pretty quick. So we're not looking at this case 15 years later, which would be a nightmare. We're looking at this case going to trial maybe 4 years after the previous trial. And Alec Murdaugh's not walking out of the jailhouse today. Prison. Jailhouse just sounds more artful, doesn't it? He's not walking out of the jailhouse today or tomorrow or the next day because he was sentenced to 28 years on the state financial fuckery cases, official title, and then 40 years on the federal financial fuckery cases. And you'll remember in the federal financial fuckery case, and you're like, Emily, ADHD, I don't remember. It's okay. I say you remember because I know that it's in there somewhere. It's fine. The federal financial fuckery cases had something I hadn't seen in a minute. The federal judge actually said to the prosecutors through their ruling, hey, those are very loud helicopters. Hey, you didn't ask for enough time, prosecutors. We're going to give you more. We're going to give you more. And so, more time. Will this affect where he's being housed? Only if he needs to be in local custody when he goes to court. But no, it's not going to shift him from state prison to federal prison. But it could move him to a different security classification. That could happen because now he is not convicted of murder. Now he is pending a murder trial. It could change his security designation. I don't know how much that will impact his housing at this point. But yeah, it could change his security status because at this point, Alec Murdaugh is not a convicted murderer. Alec Murdaugh is pending a murder trial because his conviction has been overturned. So now we get back to talking about Alec Murdaugh, and it is alleged. We are back to, in the court of law, presumption of innocence and alleged. Satori, I want nothing more than for this to happen. Satori in the chat said, will Becky be made to foot the bill considering she's the reason for the retrial? I wish that were the case. I wish that were the case. I don't see any mechanism under the law to make that happen. Proud Canadian said, but he is a convicted murderer. He is not a convicted murderer. His trial's been overturned. He is not a convicted murderer. that trial has been overturned. So there is no verdict in that trial. You have to doodly boop it out of your brain. I know. It's hard to doodly boop it out of your brain, but it's like doodly doot, doodly doot, doodly doot. That's been overturned. I know. It's like Men in Black. It's like, but I watched the case. I saw the evidence. I formed my own opinion. Right. But in the eyes of the law, Murdaugh is now presumption of innocence, has not been convicted, and is pending a murder trial. I know. So, we're going to try to doodly boop ourselves back in time. No, we're just going to go back to yesterday. We're just going to go back to yesterday. We're going to go back to yesterday and get this. Is he convicted of the financial crimes? Yes. He's a fraudster. He is a thief. He is a liar. Hey, Travis. I'm streaming. What do you need to show me? You can absolutely show me. Travis is home today. I like it.
I need to paint this though, because it
looks fantastic, buddy. That is very cool. Did you want to show the chat? No. Well, you can show them when they're done. But now chat's like, did you bring enough for the class?
Alt and weird, and it's not.
It's not alt. It's not weird. I mean, it is alt. He changed his sneaker. He's getting ready to paint them.
A chain, and then I didn't have a clip, so I used a pin, and I just need to paint the pin.
He's getting ready to paint his Converse today, I think.
I got nothing better to do.
I mean, you're not allowed to wear them to graduation, which is a bummer.
You're also not allowed to paint your cap, which is dumb.
I know you're not allowed to paint your cap.
What kids did is they took like cloth with pins on it.
Yeah, so you can take it off and put it on. Yeah, you're not allowed to paint your cap. Not allowed to wear his Converse to graduation. They have expressly been told either dress shoes or dress boots. Dress shoes or dress boots. Those are your options. Those are your options. And they're not allowed to paint their caps. I know. It'll be fine. All right. It's always good to see T. Pop it into chat. The kids are home today. Trav is done with high school. Griffin has some end of the year things. It is May. It is May. So Shakia, I agree. Shakia said they're sucking the fun out of graduation. They're sucking the individuality out of kids. I mean, but that's not new, right? It'll be fine. I definitely wore dress flip-flops to my graduation. I think actually they were more like a heeled sandal, but yes, also heeled sandals on a high school football field are a bad idea either way. Alrighty. Trav is at public school. Not a private school. What kind of school? Nope, public school. And he's had, I've loved many, many things about his high school experience. And if I start talking about them, I'm going to start to cry. I can't do it. Our band director is, God love a great band director. I can't talk about it anymore. Y'all who have been there know what I mean. You know what I mean? We love a great band director. The amount of lives that are touched by great educators can't be adequately stated by me. But he has had some tremendous educators who have had such a positive impact on him. And I'm so thankful for that, because you can only do so much of it as a parent, and having incredible educators that are invested in what they do and invested in kids becoming incredible humans. It's such a blessing. It's such a blessing. Can't talk about it. Let's talk about the Supreme Court. We're going to tap back into rage. I did clock at the very end of this opinion, because I did not read the entirety of the opinion, but there were parts I needed to read because I was on Carson and Kennedy this morning talking about this opinion. I clocked a few sassy footnotes for y'all. Yep. All right. I mean, fun fact about me, my dad was also an educator, a retired educator. So I have a very big heart for our educators, as I think all should. The great ones do so much good. All right. Should we fly to South Carolina? Should we fly to South Carolina? Against our will. Charleston is lovely. Dave's not playing there this summer, though. But Charleston is lovely. And it's only a 3-hour drive from Charlotte. So if you accidentally book yourself to the wrong airport between CLT and CHS, you can drive. Most of you know how I know that. Let's go to South Carolina. I know. Dave's not playing in South Carolina this summer. I'm real bummed about it. Dave, by the way, as like 4 of you know, played at the Magic Kingdom yesterday, played it at the World, and it was wild to see Dave playing a private concert for whatever conference had rented out Disney World, or at least Magic Kingdom Disney World, for a private Dave Matthews Band concert. I didn't know that was a level of life goal that I needed to unlock, but could you imagine a private Lawnard concert at Disneyland, not Disney World, because humidity and the land? Can you imagine? Oh, it would be fantastic. Okay, my screen wants to play Sassy Pants today. Even my tech is just like, you know what? Do we really need to talk about Murdaugh again? Yes, Murdaugh again. More Murdaugh is what's happening. More Murdaugh. This is the case that never ends. Right. Let me just look at that. Emily, are you keeping it in dark mode? Yeah, it's easier for me to read. I'm exhausted this week. My brain is already struggling. We're going to accommodate ourselves. We're going to just take care of our accommodations. Ooh, Dollywood's a solid plan, actually. Dollywood would, dude, theme parks aside, Dave Matthews Band at the Ryman would be so fucking amazing. It would be so amazing. It would be so good. My in-ears are like pulling my shirt the other way. It would be so good. All right. This is from yesterday because, of course, everything decided to happen on May 13th. State versus Richard Alexander Murdaugh. For those of you new to this case, yes, his first name is Dick. I know. It is what it is. Him and his lawyer, Dick Murdaugh, Dick Harpootlian, because it is just another name for Richard. For those of you new to this case, go ahead and put a 1 in the chat. If you did not live through Murdaugh version 1 with us, go ahead and put a 1 in the chat because I just need to know. I need to know how much background of all of this case. Oh, there's a bunch of you. Okay. Welcome to the okay. Let's do a quick road so far. There's a bunch of y'all. Quick road so far. That's fair. And this is why I asked. Quick road so far. Alec Murdaugh was part of a legacy family in South Carolina that folks like me growing up in Southern California look at and go, that shit still happens? Yes. Everyone from South Carolina was like, girl. And I'm like, okay. His family had been the elected DAs, the solicitor, in their jurisdiction for almost 100 years. They were the top elected prosecutors. Shit happened at trial, and I was like, what? Murdaugh was rolling around this county with wee-woos on his personal vehicle because he was allowed to have them. He wasn't law enforcement. He wasn't a prosecutor. Prosecutors don't have wee-woos on their cars either way. He wasn't a prosecutor. He wasn't law enforcement, but he had a badge, a gun, and red blue lights on his personal vehicle, installed by the same place that installs them on the police vehicle. That's where we start. So we are dealing with legacy family. There was a history that started to crack after his son, Paul, who was one of the victims in this murder case, was in a boat collision under the influence. There is still ongoing argument about whether or not Paul was under the influence. Based on everything I know, it is my opinion that Paul was under the influence. Alec Murdaugh showed up at the ER and started talking to kids from that incident immediately. Paul was driving the boat. They're still arguing at times that Paul was not driving the boat. Paul was driving the boat. Paul crashed the boat into a pylon because he was speeding through the waterways at night in the dark. And one of the friends that was in the boat, Mallory Beach, was killed. Others were injured. The civil litigation in the boat crash was part of a gathering storm of consequences for Murdaugh, including that his law firm was narrowing in on the fact that the money wasn't mathing correctly. And as this all spilled over, Alec Murdaugh was stealing from clients, stealing essentially from his law firm by not paying them their share. His brother also worked at this law firm, had created a fake Forge account, a fake account to funnel money into, had manipulated those who needed him most as representation, including the sons of his housekeeper who died, they say, by a slip and fall on his property, where he was like representing himself to sue himself, but then he took all the insurance money for himself. There is still ongoing litigation in the Mallory Beach case. There is ongoing insurance litigation. He was convicted of numerous fraud and financial fuckery crimes, a lot of which involved stealing from his most vulnerable catastrophic injury clients. And all of the Alec Murdaugh stealing was coming to life. And I was like, oh, this is some Girardi type shit. Yes, it is. This is some Girardi type shit. And I was like, we got one of those in South Carolina too. We got a Girardi in South Carolina too. And then there was this mysterious shooting on the side of the road where Alec Murdaugh had been shot. And then it came out very swiftly that that was a staged suicide attempt where he had somebody come to the side of the road to shoot him in the head. Right. And then as that was all swirling, then he got charged with murder. And I was like, what? I started covering this case in the theft part after the roadside insurance fraud, fake hit, fake shooting. He did, in fact, get shot. I mean, ish. He didn't get shot much. Got shot just a little bit. And then he got charged with murder. We were already looking at lawyers stealing from clients. Don't worry, we'll get back to some of that. I mean, nowadays, it's not necessarily lawyers stealing from clients that we're going to be looking at so much. It's lawyers getting fined by the court for ChatGPT. But don't worry, I've gathered a long list of cases. There are numerous other deaths surrounding this family that are questions that are still not answered, including the death of Stephen Smith. And so as you start to look at this, there are a lot of unexplained circumstances. And the gathering storm of those circumstances culminates in Alec Murdaugh's wife, Maggie, and son, Paul, who Murdaugh calls Pawpaw. It was horrific to watch Murdaugh blubber through his testimony badly. He did get all the face water involved, though. He face watered himself while he was testifying. It didn't come off more authentic, but he did face water himself. It was wild. But he said that somebody just came onto their massive property and shot his wife and son and left no trace. And then he was tried for their murder. He was convicted of their murder. And then the appeals began. And that's where we are today. We're in that appeal. So hopefully that road so far helps. A lot of you were like, oh, I remember seeing about this case now. Yes. So I know a lot of you are like, I can't do the snot. I can't do the snot. I can't do the snot. I think the face water was authentic. I don't think what he was saying was authentic. I think the emotion was real for himself, for sure. I was surprised. Do you guys remember at closing? I mean, there was so much that happened in this trial. The defense pointed weapons at the prosecution table. What tempting during trial. Coroner armpits? Seems about dead. Fucking wild trial. Wild trial. Attorney Metters is attorney / fire and brimstone preacher. I think at one point he actually hit the railing where the jurors were sitting, like hit the railing as he was talking. South Carolina. And then Creighton Waters, during during cross-examination, looked at Alec Murdaugh and said, "Are you a family annihilator?" I was like, holy shit. Oh, a feisty trial. 6 weeks of a feisty trial. And we're going to do it again. The State versus Richard Alexander Murdaugh. For all of you who hate dark mode, I'm sorry. It's just easier for my brain to process the words. Today, we're trying to limit the struggle. Heard February 11th, 2026. We were there. Filed May 13th, 2026. We were unwittingly there. We wanted to be in Utah. Per curiam. For 6 weeks, I love the drama. Come on, South Carolina. For 6 weeks in early 2023, the eyes of the nation focused on Colleton County, where the state prosecuted notorious former attorney Richard Alexander Murdaugh for the murders of his wife, Maggie, and son, Paul. It's written like the intro to a docuseries. And for those of you listening in the background, that was verbatim what the Supreme Court wrote. I'm just reading it. I'm trying to also read it in dark mode. Did it work? Notorious former attorney Richard Alexander Murdaugh. Both the state and Murdaugh's defense skillfully presented their cases to the jury as the trial court deftly presided over this complicated and high-profile matter. However, their efforts were in vain because Colleton County Clerk of Court Rebecca Hill placed her fingers on the scales of justice. The fact that they didn't say greedy, grubby little fingers is restrained. I don't know if I've ever seen the drama llamas that are coming out of the woodwork in the South Carolina Supreme Court. Look at y'all. They're just like, here's tea. I'm here for it. However, do you notice what they've done in this beginning? They've complimented the attorneys. They've complimented Judge Newman. And they've placed the blame squarely on Courthouse Becky. They say the efforts were in vain because Courthouse Becky, my summary, placed her fingers on the scales of justice, thereby denying Murdaugh his right to a fair trial by an impartial jury. Our justice system provides, indeed demands, that every person is entitled to a fair trial, which includes an impartial jury untainted by external forces bent on influencing the jury towards a biased verdict. Although we are aware of the time, money, and effort extended for this lengthy trial, we have no choice but to reverse the denial of Murdaugh's motion for new trial due to Hill's improper external influences on the jury and remand for a new trial. Because we order a new trial on this basis, it is not necessary that we review every evidentiary issue Murdaugh raises on appeal from his conviction. However, we address the admissibility of Murdaugh's financial crimes to offer guidance on this thorny issue to the trial court on remand. Oh boy. Oh boy. Becca-boo, what did you do? Oh wait, we know. We know what you did. Woman of Steel in the chat asked, will Becky be prosecuted? Becky was prosecuted for financial malfeasance and abuse of her office. They chose not to prosecute her for jury tampering. And they made a very lengthy statement about it at her plea deal hearing. However, the standard for the Supreme Court to review Becky's interference and the standard for jury tampering at a criminal trial are not the same. They're not the same standard. All right. Factual and procedural background. On March 2nd, 2023, EDB was trying to get her son picked up from band practice. And this jury came back with a verdict in like 3 hours. And I went, what the fuck? And then I got home and we did the verdict together. On March 2nd, 2023, Murdaugh was convicted of the murders of his wife, Margaret Murdaugh, his son, Paul Murdaugh, as well as 2 counts of possession of a weapon during the commission of a violent crime. The trial court, Judge Newman, sentenced him to life in prison. Like fourth fucking with, by the way. Everybody's like, are we sentencing him? The next day. And Judge Newman basically was like, I hope they haunt your dreams. I hope what you've done here haunts your dreams. Court Penn, I'm going to hold on to your question. We'll get to that. It's a great question. I wanted you to know I saw it. I'm going to hold it. We're going to get to it at the end of this. So, on March 2nd, Murdaugh was convicted of the murders of his wife and son, as well as 2 counts of possession. The trial Judge Newman sentenced him to life in prison, period. While his direct appeal of these convictions was pending at the Court of Appeals, Murdaugh filed a motion to hold the appeal in abeyance and allow him to file a motion for new trial. Nerds, listen up. The procedural history of this is fascinating to me. There were multi-levels of appeals going on here, and that's what they're going to talk about next, because there was the direct appeal to the Court of Appeals and also the motion for new trial going on simultaneously. And then everything ended up back up at the Supreme Court. You can't just go to the Supreme Court. You've got to go to the Court of Appeals. So this is what they're talking about. They're talking about their procedural history here, about the appeal being held in abeyance so he could file the motion for new trial. That motion for new trial had previously been denied, but he filed a motion to allow him to file a motion for new trial based on new evidence, the new evidence being the courthouse Becky stuff. There's a lot of procedural history here and a lot of work that went on from the defense team. So the direct appeal to the Court of Appeals was made. Murdaugh asked to hold that in abeyance, just pause it, so he could file a motion for new trial. The Court of Appeals granted the motion. That was the abeyance. On October 27th, 2023, Murdaugh moved for a new trial, asserting Hill tampered with the jury by 1, advising the jury, not to believe Murdaugh's testimony and other defense evidence, and 2, pressuring it to reach a quick guilty verdict, and 3, misrepresenting information to the trial court in an attempt to have the court remove a juror she believed to be in favor of the defense. The Egg Lady juror. The Egg Lady juror. That's the egg lady juror. So those are the three grounds that they brought to the motion for new trial that we watched before Justice Toll. Murdaugh, and yes, it's proper to call the jury it. It's an entity, like the court, the jury. The jury becomes an it because it is an entity. It is not an individual. It is individuals. So yes, you will see courts refer to the jury as it. It is appropriate in legal writing to do so. Even though it feels weird, I know. Law things. Murdaugh attached affidavits from several jurors to support his motion. Chief Justice Beatty, I think that's the proper pronunciation, appointed former Chief Justice Toll, post-trial court, to preside over this motion, as the trial court judge had recused himself. And then he retired because he was just at the cusp of retirement. May you enjoy your retirement, Judge Newman. May you enjoy your retirement. You deserve it. You will remember that shortly before this trial started, Judge Newman's son had passed away and then was sitting there presiding over the trial of Alec Murdaugh, who was accused of killing his son. They had to take Alec Murdaugh's grandpappy's portrait out of the courtroom while he was in trial. It's like that. Continuing on, the post-trial court, that's Justice Toll, the post-trial court conducted a hearing on this motion on January 26th and 29th, 2024. We were there, by stream. During the hearing, the post-trial court asked each juror, I will never be able to say it in the South Carolina drawl, but I will try. 1, if the guilty verdict was an accurate statement of their verdict at the time. 2, whether their verdict was based entirely on testimony, evidence, and law presented in the case. 3, whether they heard Hill make any comment about the case before the verdict. And 4, whether their verdict was influenced in any way by communications by Hill. We watched that as well. Juror X, who testified on the first day of the hearing, acknowledged hearing Hill, courthouse Becky, say before Murdaugh's testimony, quote, looks like the defendant is going to testify. This is an important day, or this is an epic day. And that it was rare for a defendant to testify. Juror X said that those statements did not impact the verdict. Those statements are improper. Juror Z, who submitted one of the affidavits Murdaugh attached to his motion for the new trial, was the first juror to testify on the second hearing date. When asked whether she heard Hill make any comments about the case, Juror Z responded that Hill said, quote, to watch his actions, to watch him closely. Juror Z added that Hill said more, but she could not remember anything else. Juror Z explained Hill's statements influenced her finding Murdaugh guilty because, quote, to me, it felt like she made it seem that he was already guilty. At the state's request, the post-trial court questioned Juror Z about her affidavit, addressing each paragraph in turn. Juror C's affidavit gave more detailed recitation of Hill's comments. Here is what that affidavit says. Toward the end of the trial after President's Day break, but before Murdaugh testified, the clerk of court, Rebecca Hill, told the jury, quote, not to be fooled by the evidence presented by Mr. Murdaugh's attorney. That goes against the presumption of innocence. Clerks of court that preside over the jury should say a few things to the jury. Thing number 1, be here at this time tomorrow. Thing number 2, Don't touch the thermostat. If you need anything, let us know. Thing number 3, does anyone have any allergies so we can appropriately procure snackies? Thing number 4, lunch will be at this time. Make sure to let us know what you want. Thing number 5, need any more tissues? Do we need a bathroom break? It's more like being a camp counselor. Thing number 6, you're dismissed for the day. We'll see you back at this time tomorrow. That's it. That's all. Let us know if you're cold. Let us know if you're hot. Let us know if you need snackies. Don't touch the courthouse thermostat. That is indelible rule number 1. If you need anything, tell us. That's all. That's it. That is it. Good morning, good evening, good afternoon. We're ordering lunch. Logistics. That's really all. Logistics. Logistics and food is what you talk to the jury about. That is it. You never, ever, ever say anything like this. This is so far out of bounds. It is so far out of bounds. And I think the punishment for Courthouse Becky should be harsher. Much harsher. Oh, fair. Science and Sass said parking. Yes. Absolutely can talk about parking. 100%. We heard that the jury in the Corey Richins case had asked a question because they were being followed by a drone, and they were told that that was from the sheriff's department to make sure nobody approached them. That's an appropriate conversation. Hey, it's weird that there's a drone following us. Are we being filmed by someone? Is someone trying to capture our faces? Fair concern, fair answer. Logistics. Logistics and security. Remember, there was also a swatting during this trial. So talking to the jury about where to go when the courthouse is evacuated, also appropriate. But that's about it. All right, continuing on. Courthouse Becky told the jury, quote, not to be fooled by the evidence presented by Mr. Murdaugh's attorneys. And the juror said, which I understood to mean that Mr. Murdaugh would lie when he testifies. She also instructed the jury to, quote, watch him closely immediately before he testified, including to, quote, look at his actions and to, quote, look at his movements, which I understood to mean he was guilty. Completely inappropriate. Completely inappropriate. It's fuckery of the first order at this point. Juror Z testified that when the jury began deliberations, Hill told the jury, quote, this shouldn't take us long. Us. And she echoed that in her fucking book. She kept in her book inserting herself as one of the jurors. We went on a view. She treated herself as, or styled herself as, the 13th juror in this case. And that is why there's a new trial. Juror Z testified that when the jury deliberations began, Hill told the jury this shouldn't take us long. In addition to referencing Hill's statements, Juror Z averred in her affidavit, quote, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Now, that is deliberation. This juror did not say that Courthouse Becky influenced their opinion. That's not the standard that the court needs to find, though. And if you have an unwavering conviction that someone is not guilty or it hasn't been proven to you, your willingness to disagree with other jurors might be subverted by the clerk of court also saying, hey, you got to watch out for them. And it's really hard to know how your brain is processing that information. It goes on to say that after reviewing the affidavit, the post-trial court questioned Juror Z. And they're quoting from that. I asked you previously, was your verdict on March 2nd, 2023 influenced in any way by communications from Becky Hill, clerk of court? You answered that question, yes. In light of what you said in the affidavit, which is, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors, is that answer that I just read more accurate or a more accurate statement of how you felt? Juror Z answered affirmatively. The post-trial court then asked if she stood by the affidavit, and she answered yes. Juror Z subsequently submitted an affidavit to clarify her testimony. This was a shit show this day. Poot was running in and out of the courtroom. It was just like, it was so much. It was so much. So, Juror Z subsequently submitted an affidavit to clarify her testimony, in which she explained that she had felt influenced to find Murdaugh guilty by Hill's remarks before she entered the jury room. And once deliberations began, she felt additional pressure from the other jurors to reach a guilty verdict. Because brains, these are layers in this deliberative process. And it's really hard to undo the layers of your impression of something because it all factors in. And I get that. And I truly feel for these jurors. They were put in a horrible position by Courthouse Becky's fuckery. They were put in a terrible position. Can you imagine? First of all, in South Carolina, this is a nightmare for me, by the way. I imagine a lot of you feel the same. But in South Carolina, when we were watching some of the process, the jurors stand up in front of the lawyers, like between where the lawyer tables are and where the judge is. And then the lawyers decide if you stay or if you go. To your face, while you're standing there by yourself. It's like, are you going to pick me or not pick me? It's like getting picked last in junior high. Do they still do that? Probably not. I imagine dodgeball is like a no, or Red Rover or whatever. It's like standing there waiting to be picked. Pick me. Or it's jury. Don't pick me. But a lot of people, don't ever want to be standing there with tables full of people looking at them, because nightmare. But also to then have to come testify after jury service about something where you did nothing wrong, and to be questioned by lawyers in the court about what somebody else did. Nightmare. They should be exempt from jury duty. Truly, they should be exempt from jury duty forever. Like, let these jurors go. They have done their service. Thank you for your civic duty. You were just can they get a pass forever? Because the stress of this, I don't know how you go into another jury setting and not carry the stress of this with you and just be like, I don't want to deal with any of this shit. Woo, boy. So stressful. And I think Juror Z tried to explain the layers of, I went into the jury room with this perception because of what Becky said. And then the other jurors, who might also have been influenced by what Becky said, were saying, well, we think this, and felt pressured to just say, find guilty, which is a problem. You want jurors to have an abiding conviction that they are doing the right thing. And this is an incredibly circumstantial case. It went on for 6 weeks. And I don't think in the realm of circumstantial cases, we have seen some that are really, really weak, and we have seen some that are really, really strong. Murdaugh's on the lower end of that scale for me, but I also see it through the lens of a prosecutor. But Murdaugh's on the lower end of that circumstantial scale. It is not a Corey Richins circumstantial case. It's not Banfield's not a circumstantial case once you get Juliana testifying, but it's not like a Walsh circumstantial case. This is a harder case. And so any influence here, any influence in any case is a huge problem. But this is a hard case. They go on to say that although the post-trial court did not admit this affidavit, it accepted it as a proffer. Thus, the affidavit is part of the record before this court, which means they can consider it. All right. We're trying to finish up the coffee. I don't know if I'm caffeinated enough for this, but cheers, Leonard. It was really good coffee today. Coco B, I agree with you. I think the Snapchat video is pretty devastating. Yeah, I think the Snapchat video is pretty devastating. I do. Continuing on. Juror P testified that the day Murdaugh was to take the stand, Hill made a comment to, quote, watch his body language. He denied Hill's comments influenced him in any way, footnote 1. The remaining jurors testified that they did not hear Hill make any comments about the case, and they were not influenced by any comments Hill made. Multiple jurors heard Hill say the same thing. Footnote 1. Footnote 1. Following Juror Z's testimony, the post-trial court informed the parties that the other jurors who were waiting for their turn to testify had tuned into the proceeding on court TV. I remember that. The jurors either denied viewing the proceeding or, if they saw it, asserted it would not influence their testimony. They were waiting to testify, and they had their phones out and were watching it streaming. Because I don't think anyone had told them not to, because they weren't in trial anymore. So they were in the holding room watching the proceedings. I don't think anyone told them not to. That day was a roller coaster. Following the juror's testimony, the state called Courthouse Becky as a witness. If you have not watched the testimony of Courthouse Becky, we will link it below. It's time to catch up on that shit. Yep. Not right now. Stay here right now. But if you're looking for something to watch over the weekend, start there. Start there. Because damn. All right. Golden Dragon, this is a great question. Golden Dragonette said, why would they need to be told not to watch the stream? Because here's where I'm at with this. When you are in trial, you are given such express instructions. You can do this, you can't do this, you can't be here, you can't be here. They're no longer in trial. They're being called in to be questioned. And the expectation that has been built with the jurors is if something's a problem, we'll tell you that it's a problem. So if we don't tell you it's a problem, then it's not a problem because we're not in trial anymore. We're not rendering a verdict. We're just being asked. And I want to know what everybody else has to say. So I can understand why jurors would be like, I mean, they didn't tell us like we couldn't. They told us every other time we couldn't. So if they didn't say anything, it's probably fine. Like I get it because they've been told so expressly what they can and can't do with regard to media. And this was being questioned after the verdict was rendered. So yeah, I understand. Following the juror's testimony, the state called Hill as a witness. Although Hill denied making most of the comments the jurors related. She admitted that on the day that Murdaugh testified and within earshot of some jurors, she spoke to the bailiff about Murdaugh's decision to testify. She also stated that she gave the jurors a little talk. Ma'am, this is not kindergarten. Their jurors don't need a pep talk to put on their listening ears. What are we doing? She gave the jurors a little talk, instructing them to pay attention and that the day was a big day. She denied attempting to influence the jury. There's no little talks. Be here at this time. Don't touch the thermostat. Snackies. There's no little pep talk. Big day, everybody. Put on your listening ears. Pay close attention. Because he's a fucking liar. No, ma'am, you cannot. In discussing her book, Behind the Doors of Justice, The Murdaugh Murders, footnote 2, Hill claimed literary license to explain some of the more dramatic passages. She denied wanting a guilty verdict because it would sell more books, claiming the outcome of the trial did not matter to her. But she acknowledged as true a passage in which she stated she believed Murdaugh was guilty, but was concerned he would be acquitted because of his family's goodwill in the community. So the motive then? Oh, there's a footnote. Footnote 2. As her book title suggests, it turned out Hill was quite busy behind the doors of justice, thwarting the integrity of the justice system she was sworn to protect and uphold. The book was pulled from publication because Hill plagiarized portions of it. I am living for the level of Petty Betty on the South Carolina Supreme Court. They're just going to read your ass to filth in a footnote. That is a sassy ass footnote. Like, first of all, she was just a busy bee behind the doors of justice, giving people access to sealed exhibits, which was part of her prosecution. Giving access to a photograph of Murdaugh while he was in his holding cell. And plagiarizing part of her book. She would have done better asking Corey Richins to write it, but then it would have just been trite platitudes. Guilty is as guilty does or some shit. I don't know. I don't know what Corey Richins' impression of the Murdaugh trial would be. But this footnote is fucking wild. Look, I have read a lot of Supreme Court opinions. It's a central feature of law school. I love a good Supreme Court footnote. There are some sassy fucking footnotes. This is next level sass, and I am here for it. I am here for it. Get it, South Carolina Supreme Court, because at least you're going to bring a little bit of the gossip amongst all of this, because there was so much tea going on. Continuing on, the post-trial court, that's Justice Toll. I have an answer. Ashley, I know the answer to this. Not that I don't believe it, but do we know where she plagiarized from? Yes, we do. And we saw it play out in real time because her emails were FOIA'd. Let me tell you, side quest, brief side quest. Her emails were FOIA'd. I covered that too. I think it was FitzNews that FOIA'd them. Her emails were Freedom of Information Act requested. And in her emails, a journalist from the UK, I don't remember which publication, had sent her an email with the beginning of the article they were working on, and she directly ripped it into her book. So it was verbatim an email that she had received from a journalist. And in those emails, she was also just kissing ass to the media. There was information that indicated in the emails she was giving out jurors' cell phone numbers to the media. She was brokering media appearances, including, was it GMA or the Today Show? Chat, you'll remind me where the jurors appeared first. But she was brokering appearances of the jurors for the media and went too, because she wanted to ride on an airplane to New York City. And so she went with the jurors that were on GMA/Today Show. I don't remember which one. And brought the jurors there. She was also currying favor with like Nancy Grace and others and giving them her cell phone number, getting their cell phone numbers, and signing her emails XOXO, not Gossip Girl. Could be. XOXO, Becca Boo. Dead ass. I'm too old to use that phrase, but it's the only one that fits. Yeah. She was currying favor with the media that she liked because it put her, all eyes on me, in the center of a ring, just like a circus. And she referred to the media circus and loved it. XOXO, Becca Boo. Wanted to be in the middle of all of it. And not, I want to be where the media is. Emily, are we going to start singing The Little Mermaid? Yeah. I want to be where the people with cameras are. I want to see them. Well, loving me is really what she wanted. Remember, her daughter was like outside with a hat playing guitar for members of the media, and they were tipping and paying her daughter. There were emails that people were just like, I don't have cash. Can I Venmo? Can I Venmo a tip to your daughter, teenage daughter? There was a birthday party that was hosted. This is on top of her stealing funds from the county, paying herself too much, taking funds to host parties for the members of the courthouse. Some of those funds coming from the federal child support funds. Yeah, we did a whole deep dive on the courthouse Becky fuckery. She was giving tours of the courthouse. That's right. Tag you it. Yep. She was giving tours of the courthouse. She was charging people to come in and like take pictures. She was charging people to come, that they were paying her to come into the courthouse. She had a whole racket she was running. She used the courthouse for the photo shoots for her book. The whole thing. She's an elected official. She is an elected official. Emily, elected officials get up to fuckery all the time. Yes, and they should all be prosecuted. It doesn't excuse that she's getting prosecuted. She is a low-level clerk of court. Easy to prosecute her, put her on probation, and send it away. But she shouldn't be doing it. Also, it's a courthouse. It's not MTV fucking Cribs. And she was lying to the people that were doing tours, saying it was going to like the historical preservation blah-de-blah. Which I could understand being like, we should preserve the courthouse, the history that has happened here. Fucking Becky. If there is a definition of clout goblin, CEG Becky Hill. And we haven't even gotten to the fact that her son, who worked at the IT department in the same county, was wiretapping other employees, seemingly in coordination with Becca Boo. They talking about me? What are they saying? That case is still pending. The son's case is still pending. We need a whole fucking chart. The level of tea. I know. It is a full ass soap opera down at the Piggly Wiggly. All right, continuing on. I love a Piggly Wiggly, by the way. I'm not sassing about the Piggly Wiggly. I love a Piggly Wiggly. But the community should be giving Becca Boo all the dirty looks, because she's costing all of you, taxpayers of South Carolina. You elected her. You believed in her. And she is going to cost you millions and millions of dollars. So if you yell shame at her in the aisles of the Piggly Wiggly, I say don't go real world with people, but it's your tax dollars. I'm sure Becca Boo's getting enough looks. However, there are probably some that think she is also a victim of Mr. Murdaugh. Becca Boo's a victim of nothing but her own ego. Let us be clear. Just do your job. You do not become an elected clerk of court for recognition. If you want to do that, be a state senator. Obviously. You become an elected clerk of court to do justice in your community. And oftentimes, everybody's just mad at you. When you work in the justice system, most of the time, everyone's just mad at you. And everybody was just like, oh, Becky Hill's so great. I'm not done, clearly. Oh, Becky Hill's so great. Oh, Becky was so sweet. Oh, Becky was so accommodating. She was navigating people in through the side door of the courthouse so they could skip the line. Oh, don't worry, I got you. She was leveraging her access for others. And I honestly don't blame the media for playing that game, because of course they are. That's the media's job. This is how TMZ knows everything before the lawyers even do, because they have those within the court system who are just like, guess what? That's what they do. It is the job of the elected official to be the adult in the room and say, no, there's rules. We need more neurodivergent people in positions of power. Because you know what? Someone else needs to manage their calendar and tell them to get to meetings. But you know what they're doing? They're following the rules to an annoying degree. They're going to find a rule that you didn't know existed and follow the rule. We need more of the neurospicy in this type of position of power. You want them to follow the rules to the letter of the rule? Perfect. They got you. They got you. You're going to be like, can you do this? No, I can't do that. I can't do that. I can't get to a meeting on time. That's fine. Give me 10 minutes. But no, I'm not going to do that. The rules are this. I'm following the rules. So don't ask me not to follow the rules. It's going to make everyone real uncomfortable. But Courthouse Becky was following the siren song of celebrity. Emily, that's a beautiful turn of phrase. Thank you. It's not mine. The incomparable Justice Toll is the one who said that. So, continuing on. The post-trial court, Justice Toll, also questioned Hill about the favors she granted the media. Emily, keep reading. Hill denied allowing the press to view the exhibits. I changed the word, including the sealed exhibits. However, she subsequently pled guilty to perjury stemming from this denial. Deadass lied to Justice Toll's face, no cap. Perjury. Y'all are just like, EDB, where's the perjury? One, we've gotten one in the time I've been covering this here. I did do a perjury trial. It was one of my favorite trials that I ever did. I had way too much fun. I was a bit dramatic in that. I loved it. I did do a perjury trial. Perjury is not, criminal perjury doesn't come up all the time. She pled guilty to perjury. I know there's finally a keep reading emoji. I know. We finally did it. Thanks, Team Baker. When we rolled out the new emoji, when we rolled out the new emojis with this launch, the keep reading one got added. We also added a fun little update to the app. So if you have an app update, don't forget to do that. Perjury is rarely prosecuted. She was literally caught, well, in 1080p because courthouse cameras. And we went back and watched it again when all that went down. We're going to need to break out a separate, I think we have a separate Courthouse Becky playlist if you need to catch up on that. She allowed the media to view sealed exhibits of the victims. Look, I can't think of anything more violating. It is such an incredible violation. First of all, the indignity of getting murdered by your spouse, but the added indignity of people who don't need to view your dead body having access to that is horrific, depraved, and disgusting behavior. They should make Courthouse Becky go sit in a bunch of autopsies. She might feel differently about it after that. Because if that is an experience that will change your perspective on things, they really should. Go sit in a bunch of autopsies, Courthouse Becky. See what the victims go through after they're dead to find evidence in the cases that take so much time, money, and energy. And then to allow access to that for your own ego so you can just be the definition of a clout-chasing pick-me is awful. Emily, you've broken all your rules today. I'm going with descriptors of behavior. This behavior pisses me off. And at the very beginning of this, I went, ooh, what is the defense spinning up? I was full trust but verify because I don't want to believe that somebody who says that they are taking a role in the court system for altruistic purposes are going to turn around in full narcissism and direct all the attention to them. It's appalling. Although the post-trial court limited discussions of Juror 785, we'll get to the footnote in a moment, whom the trial court dismissed the day deliberations began for allegedly discussing the case. Oh, that's interesting. We're at Egg Lady, juror. For those of you who are like, Emily, what are you saying? The day that this juror was dismissed. By the way, this juror was there for 6 weeks of trial. And the day of closing arguments was dismissed and asked if they could go back to the jury room and get their eggs because another juror had brought in farm fresh eggs. At the time, eggs were how much a carton? Ridiculous. Eggs were ridiculous a carton. And all of us were like, fair question, go get your eggs. It's like $10. Well, farm fresh eggs, that's like $13, $15 worth of eggs. Yeah, go get your eggs. But that's how they became called the Egg Lady juror because they're like, I know I'm being dismissed, but can I go back to the jury room and get my eggs? Fair. I didn't know how strongly I would feel about wanting to have chickens. And then I reached the age of millennials wanting to make, even though I'm a zennial, but wanting to make sourdough and have chickens. Yeah, I'm that years old. They say allegedly, which is interesting to me. They say the discussion about Juror 785's dismissal for allegedly discussing the case with third parties. It allowed Murdaugh to question Hill about bringing to the trial court's attention social media posts that Hill mistakenly believed were from Juror 785's ex-husband. Hill claimed that the juror was very talkative. She's telling them everything. While Hill walked her to the trial court's chambers and volunteered that there were restraining orders on her ex-husband when they divorced. You should never know this about a juror. You should never, ever, ever have this type of conversation with a juror. Mibs, don't worry about it. There are 2 types of zennials, zennials with an X and zennials with a Z. They are the kind of overlap generation at the top and bottom of the millennial generation. So there are zennials X that are on that squishy bit between Gen X and millennials. And then there are Zennial Zs at the very youngest end of the millennials into the oldest end of Gen Z. So I'm at the youngest end of Gen X, at the eldest end of the millennials. So I'm right in the squishy bit as a Gen X millennial, where I have some of the Gen X experience, but also the digital experience of an elder millennial. So we fluctuate. Dr. B, Gen X, though sometimes I tease that he is a Gen X boomer. He loves that when I do that. He loves that when I do that. Let's take a look at this footnote 3 about Egg Lady Juror. It literally just names the Egg Lady Juror the Egg Lady Juror. Footnote 3, this is their footnote. When the trial court dismissed Juror 785, she said her belongings left in the jury room included a dozen eggs, which another juror had brought her. She then became known as the Egg Juror or Egg Lady because it was streaming. And it's like, which juror is that? We didn't know what juror number it was. We didn't know what jury seat they were in. We just heard the juror say, "Can I get my eggs?" Henceforth, Egg Lady Juror. Yes, it became a shorthand. Great footnote. This was also an entire fight. This was an entire fight over this juror. There was a lot more discussion here. We are skipping over it for today's purposes, or we will never be done streaming. In response to the post-trials court questioning, Hill continued to deny initiating or engaging the juror in discussions of those matters. I don't believe Hill on this one. I don't believe that Hill did nothing to initiate those conversations. I'll tell you why. I've done a lot of trials. That is one of the features central to working in LA County, is that there are a lot of trials. And I, at times, was doing multiple trials a month. There were times I did multiple trials in a week. What I have found for the most part, and all of you, I'm sure, can relate this to your own work experience in different ways, is when you come in to the court system as a juror, you are waiting for others to kind of tell you what to do. It is a new environment. It is a little bit intimidating, and you don't want to do something wrong. And so jurors tend to be more cautious. They are not super at home in that environment. The courthouse staff are the ones in the lead. And so it is harder for me to believe that a juror would just start opening up and talking about all this stuff when they are advised not to talk to court staff, to just logistically let them know something. If you have a doctor's appointment, then let them know you're going to be late. We'll figure it out. But they are reminded to be cautious in their conversations. So it would be unusual to me for a juror to just be like, "Oh my God, and then my ex, and there's this restraining order," blah, blah, blah. Unless that conversation was initiated by Courthouse Becky. And given the fact that Courthouse Becky was a talker, as we have seen, it is easier for me to believe that Courthouse Becky's initiating those conversations. And then the juror's like, "Oh, well, if she's having this conversation, then it must be okay." Because they wouldn't be breaking the rules. Because it's the sweet little clerk of court. She's just sweet little grandma. Her sweet tea is the best. She would never. What are we growing in South Carolina? Roses? Peonies? What are we doing? What are, let me know. You know, she's taking her pie to the county fair. She grandma. She wouldn't be up to fuckery. So I don't necessarily believe that Courthouse Becky was not initiating a bunch of those conversations. It's hard for me to believe. It strains credulity for me. It then goes on to say that in the affidavit, hydrangeas, fair. Hydrangeas are fair. Tomatoes, right? She's like, My pumpkins have won. Exactly. And by the way, I think that showing things at the county fair is amazing. I always love to go look at them. But this is the persona, right? Thank you all for letting me know what's in the garden. You know it's that time of year. All Emily wants to do is grow things. And today the weather is so lovely. I will definitely be in the garden. So, continuing on. In the affidavit, the egg lady juror related that Hill, knowing the juror's fears about her ex-husband, informed her that law enforcement officers question the ex-husband about the posts. In the light, for me, in the light most favorable to this juror, if you have an ex that you have a restraining order against, and all of a sudden you are being told that law enforcement is now contacting that ex, I can see very reasonably that that could cause someone to panic. Because what is the fallout going to be if they have now contacted the ex? What fallout is going to come from that? I can understand that. I can understand that that could be a very real concern. So Becky is alleged to have told the egg lady juror that law enforcement chatted with the ex about posts on Facebook and then offered to reinstate restraining orders that juror 785 had against him and speculated that, quote, the Murdaughs probably got to him, to the ex-husband, when he called juror 785 the morning of the verdict. Do you think Courthouse Becky told egg lady juror that the Murdaughs probably got to him? We're still in the statement of facts. That's how much of a fucking soap opera this is. But it's playing with people's lives. Juror 785 asserted that Hill asked her whether she and the other jurors were inclined to vote guilty or not, and told her that everything Murdaugh said had been lies. And when I have evaluated this, there are parts of this that I believe more than others. I believe that some of this may be exaggerated a bit. Not all of this rang true to me, but I don't think all of it is exaggerated. I think some of it may be, but I think that she and this juror had an inappropriate conversation. I think that was initiated by Courthouse Becky. I don't know if some of it was then bolstered after her conversation with defense counsel, but I think that the conversations happened. Asking how they were voting, I don't know if that happened in that way. However, with everything else that happened, when you're the Court of Appeals, you have to look at the totality of Becky's behavior, for sure. Egg Lady Juror also stated that before Murdaugh testified, Hill told the jurors not to be fooled by the evidence Murdaugh's attorneys presented. I believe that part. Absolutely. Numerous jurors reiterated that. Oh, we're getting to my favorite witness. I loved this witness. This witness is the definition of help me, Rhonda. The court now goes on to Rhonda McElveen, the Barnwell County Clerk of Court, who assisted Hill with the trial. Rhonda testified that Hill repeatedly told her she wanted to write a book so she could buy a lake house, and a guilty verdict would be the best way to sell books. I believe Rhonda McElveen 1000%. I also believe that Rhonda was holding back a level of rage at Becky's blustery, pick-me diva behavior. Rhonda's like, we're here to do a job. We got to get these courts running smooth. Get these jurors in, get these jurors out, get these trials done. And Rhonda, when she testified, said similarly, she doesn't talk to the jurors. Literally, tell them when to be there. Don't touch the thermostat. Snackies. Rhonda was great. Rhonda's a 10 out of 10. Rhonda, you deserve the lake house. Or the beach house. It is South Carolina. From South Carolina, where would you get a lake house? Locals, let me know. Because from here, you would look either in Tennessee, Alabama, Georgia, Arkansas, maybe Kentucky. But you let me know from South Carolina where you're going for your lake house, not beach house. Either way, these are things unknown to me. She goes on to say that Rhonda testified after hearing Hill had given a juror a ride home. I forgot about that. That there's some fuckery. After Hill had given a juror a ride home, McElveen counseled Becky that it was inappropriate. And while Hill admitted that she gave the juror a ride, she claimed that the bailiff was with them and they did not discuss the case. Footnote 5. I had forgotten about that. The fact that Courthouse Becky is so comfortable with all of this causes me great concern. We have found the grave concerns, law nerds. Here they are. Here are the grave concerns. Footnote 5. At the hearing, Hill denied giving a juror a ride home. Hill lied in that hearing multiple times. I don't believe Hill for a minute. Although McElveen did not hear Hill say anything inappropriate to the jurors, she stated that Hill made comments to her, to staff, and to media members strikingly similar to those Juror Z reported. I believe Rhonda McElveen. Just like when we were watching Donna Adelson's case, and Donna was the one being like, you fool. Donna wrote the letters. Donna's the one saying, you fool. People's language tends to be similar, especially when they are unguarded and unclever. Emily, that's not a word. It's fine. It's appropriate here. It fits. We're making it work. That she was saying essentially the same thing to the media, to the staff, and to her. The clerk of court should not be telling the media what she thinks of the evidence. The clerk of court and the court reporter might be having those conversations. Sure might. But shouldn't be talking to the media about it. What are we doing? Rhonda McElveen stated that Hill made comments to her, McElveen, staff, and media members strikingly similar to those that Juror Z reported, such as advising them not to be fooled by Murdaugh's attorneys and to look at Murdaugh's actions and movements while he testified. Humans watch humans when they testify. You don't need to tell them to watch the defendant's testimony. Jurors are naturally locked in on what the defendant is saying. You don't need to tell them. Why is she this comfortable with this level of fuckery? Oh, maybe it's because she was also siphoning off funds and not getting caught. Maybe. Finally, McElveen testified that Hill seated a writer with court personnel. This writer wrote the foreword for Hill's book. Was that part of the plagiarized part or nah? And I think there was also a photographer that Becky was giving special access to. Next, We're still in the statement of facts. Betty Green in the chat's asking the real questions. Did the egg lady juror get her eggs? She did. Next, Murdaugh called the alternate juror to testify. We're still talking about that hearing that I covered back in January, 2024? The alternate described the incident in which Hill made comments before Murdaugh put up his case, stating that while the jurors were assembled in one of the two jury rooms or were standing in the hall, Hill stood in the doorway and told them, quote, "They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off." The alternate juror also testified that Hill told the jurors not to be nervous and, quote, "Don't be afraid to show your emotions because that's what they want to see." I have thoughts on who I think the they is. Who do you think the they is in that comment? I'm going to let you guys answer. They go on to say the alternate juror related that she heard a court staff member say deliberations should not take long, but she could not remember who said it. Yeah, chat, you're all on the same page with me. The media. I thought so too. I think that Becky Hill was trying to get the jury to perform for the media that were all sitting in court so they could report it. Because what would that reporting garner? Lots of clicks and views. And isn't that good for her book? The more attention this case gets, ultimately, the better it is for book sales. Girl, you're not the mastermind. Can I ask you guys something? We have seen some pretty high-profile cases. Depp Heard is one of equal length, and I think more high-profile than this. Anyone know the name of the clerk of court for Fairfax County? Don't go Google it. Any idea who the clerk is that was in court day in and day out with Judge A? Right. No idea. Because they did their job day in and day out like a boss, and we've heard nothing about it. They just handled the courts. Right. The alternate juror said that Courthouse Becky told the jurors, don't be nervous. Don't be afraid to show your emotions because that's what they want to see. All of this is unprofessional and inappropriate. The alternate juror remembered she heard court staff say deliberations should not take long, but she could not remember who said it. In its order, the post-trial court, Justice Toll, declared the burden was on Murdaugh to show both an external influence on the jury and prejudice from that influence. Put a pin in that part. This is the thing I've been talking about this whole case. The standard in South Carolina and the standard that the federal Supreme Court has are different. The federal Supreme Court and many other courts do not place the burden on the defendant to show prejudice. Most jurisdictions presume that there's prejudice, and then the prosecution has to rebut the prejudice. And I said at the beginning of all of this, if South Carolina shifted their standard to align with the federal standard, then it's a new trial. Period. South Carolina has not had the opportunity to evaluate this since the federal standard changed. And I think it's fair. This is the standard not when we are dealing with external influence on the jury, but when we are dealing with external influence that is particularly a party connected to the state, a bailiff, an elected official, court staff. They carry more weight. It's like a nurse at a doctor's office and the doctor are going to carry more weight than someone in the waiting room, right? Because they are part of the justice system, their interference is higher levels of fuckery. Because you can have jury influence cases where the jury's waiting in the hallway to go into court and some random in the hallway yells something about the case. That can happen. The standard there is a bit different. The post-trial court declared the burden was on Murdaugh to show both an external influence on the jury and prejudice from that influence. I think Justice Toll was right about that standard at the time. It then found Hill made improper comments to the jurors on the day that Murdaugh testified, e.g., this is an important day or this is an epic day, and that they should watch Murdaugh's body language. The post-trial court determined that Hill's denial of making these statements was not credible. Justice Toll said that Hill is not a credible witness. Finding that Hill wanted to write a book, which she believed a guilty verdict would help to sell, and that she was, quote, attracted by the siren call of celebrity. Okay, good. Then siren song are my words. I like the alliteration better. No offense to Justice Toll, who is eminently smarter than I am. I just like the alliteration. Justice Toll also said that Becky Hill allowed her desire for public attention of the moment to overcome her duty to her oath of office and her oath as a witness. Facts. Next, the post-trial court found that these comments did not affect any juror's verdict. It explained that Juror Z's assertions that Hill's comments affected her verdict were ambivalent, self-contradictory, and not credible, emphasizing that Juror Z had acknowledged her statement in her affidavit that she had voted guilty due to pressure from other jurors, and that was the more accurate statement. The post-trial court further found that Hill's comments were limited in subject and not overt as to opinion, were only heard by, at most, 3 jurors, and were made in a case with overwhelming and compelling evidence, and that the trial court's extensive instructions cured any effect from these comments. The post-trial court concluded that while it found Murdaugh failed to meet his burden to prove prejudice, any presumption of prejudice was overcome. It therefore denied Murdaugh's motion for a new trial, denied Murdaugh's motion for new trial. Murdaugh timely appealed the Court of Appeals. This court certified the appeal of the denial of the motion for new trial and subsequently consolidated it with the direct appeal. So then procedurally, it all just got pulled up to the Supreme Court. Whoop. Kelly says, Emily, since Becca Boo felt so comfortable in all of these wrongdoings, makes me think she influenced other cases. I worry. However, we've got statute of limitations and resource issues. But I worry. I absolutely worry that Courthouse Becky was so comfortable. Yeah, she was real comfortable. And it concerns me. EDB, I wonder how Becky would autograph your copy of her book. Oh no, I wouldn't hand it to her. She might take it away. I'm not a clout goblin. No, that's not a conversation we're going to have. But yes, we have a copy of that book saved for posterity. Don't worry. Law and analysis, the Remmer presumption of prejudice. Murdaugh argues he was denied his constitutional right to a fair trial by an impartial jury free from outside influences. He asserts that following Remmer versus U.S. from 1954, prejudice should be presumed from Hill's comments to the jury, and that the presumption is irrebuttable. In the alternative, he contends that the state failed to rebut the presumption of prejudice. The state argues that the jury convicted Murdaugh because he was obviously guilty, because he was obviously guilty, and not because 3 jurors heard Hill's, quote, foolish and fleeting comments about his upcoming testimony. The state contends that the post-trial court correctly declined to presume prejudice, and any presumption of prejudice was rebuttable. We agree with Murdaugh. South Carolina is changing their standard. We agree with Murdaugh. Prejudice is presumed from Hill's comments, and while this presumption is rebuttable, the state failed to overcome this presumption. They are changing their standard to to align with the federal standard. I think that is the just result. I do not think that Justice Toll was wrong in their ruling. I think that Justice Toll was actually very mindful that the Supreme Court that she had once been the Chief Justice of would likely come to this result. But I think that Justice Toll, as a restrained and mindful jurist, also knew it was not her job to change this standard. And I think Justice Toll pretty much teed up a slow pitch to the Supreme Court to take up this question. And the reason, in my opinion, that the Supreme Court directly took this up out of the hands of the Court of Appeal is because this is really the first opportunity South Carolina has had to change their case law. So when we want to talk about how do laws change, this is how laws change. It's slow, but it takes a case because the Supreme Court can't just say, they're not legislatures. The Supreme Court can't just say, hey, our standard's outdated, we should change that. There has to be a case in controversy. There has to be something happening. There's something happening. Yeah, there has to be something happening that allows them the vehicle to then evaluate whether or not they are changing their standard, unless the legislature then writes new laws. It is not the role of the lower courts to change the standard. We saw Judge M talk about this incredibly mindfully yesterday. Judge M was talking about what the legislature had done and what he thinks they should do. It's not his role from the bench to change the legislative intent and to change what the legislator has done. The legislator did this. It is very clear what they did. I am following what they did. I do not like the result. But it is the legally proper result under the law as it is today. And that is what Justice Toll did, in my opinion, as well. This is the legally proper result under the law of the land as it is today. And the Supreme Court says, okay, this is no longer the law of the land. So going forward from this precedent, the Supreme Court has now changed the case law in South Carolina to change the standard that's applied. So this. Michelle Henson said, so when the Supreme Court sets a precedent, how does the actual law get changed? Through case law. This is the change. Because now, and it's a great question, I'm really glad you asked, because now, if this scenario ever comes up again, this is the binding precedent on South Carolina. And the next set of lawyers will pull State versus Murdaugh, citing to Remmer and say, in South Carolina, we follow the federal Remmer standard, per State versus Murdaugh. This case is now binding precedent. And that's how it changes. It doesn't need to change the legislation because this is not based on legislation. This is based on case law. And this is how we start to build the case law, or you see the case law start to be built. And lawyers build their arguments based on the case law. So this is the change. What is this going to change? Diana asked. It changes the standard that South Carolina applies. It changes the standard that South Carolina applies when there is external influence on the jury from a state actor. So it changes the way that South Carolina applies their case law, and it updates their case law. And that's what they're going to talk about next. So we are watching law change in real time. Courthouse Becky has kind of welcomed in new case law. Do you know what that also means? That this has not come up in South Carolina since 1954. Because this doesn't come up very often. Because everyone knows this is fuckery and this is what you don't do. You don't do this. This is not okay. It doesn't come up that often because it's such a big no-no that everybody knows that it's a no-no. Way to go, Becky. One of a kind. You're one in a million. Yeah, that's where we're at. Well, I guess it remains that in South Carolina, law students forevermore are going to be studying the fuckery of Courthouse Becky. You know what, though? If I'm a law student, I am fucking living for this opinion. It has so much drama and tea and sassy footnotes. And then there's an egg lady juror. And what do you mean there's another clerk of court and a lake house and a book? This in law school, this would be an entire dinner party with alcohol, sitting down and discussing what the fuck went down in the Murdaugh case. So yeah, Courthouse Becky, welcome to infamy. You now live in case law forever. You are now part of the binding case law of the absolute outside boundaries of fuckery, overturning a murder conviction. Infamy. Kate Manning, 10 out of 10. Don't forget to bring your own Merlot. Hey, T. What's up? Oh, thank you, buddy. I love it. First shoe looks great. Love the checker pattern on the back. Wait, can I see the back? Thank you for asking if I needed anything. The back has been painted. The back has been fabriced. Cool. Love it. Looks good, T. Thank you. Do we have any fizzy water? Yeah, that'd be great. Whatever we got. Thanks, buddy. All right. So I guess in some ways, Courthouse Becky gets to be famous. Infamous. Mm-hmm. Monkey Love said, I've never seen you so heated. This is when those within the system put their hands on the scales of justice, it is, I don't know how to explain the level of abhorrent it is. This is so beyond the boundaries of what is acceptable. And it goes to the heart of the system of justice. And it does not matter what Murdaugh is accused of doing, what he did, what he didn't do, who his family is, the levels of fuckery that he's rolling around after the boat crash with his fucking badge and red blue lights and all the rest of it. You have to let the process, thank you, T. You have to let the process play out lawfully. And if I was the prosecutor in this case, I would be so fucking mad. The amount of work that goes into a prosecution like this, the amount of pain it causes the family members, the expense it causes the taxpayers, and then to fuck it up like this is abhorrent. And there are a lot of defendants whose behavior pisses me off. Fair. Courthouse Becky ran for this position. She wanted to be the elected clerk of court. And then she was stealing money. She perjured herself. And she got a murder conviction overturned. It's a trifecta I don't know if I've ever seen before. And then she got probation, which also pisses me off. Probation. Hate it. Hate all of it. Professionals should just do their jobs. She had one job. You had one job. One job. So, South Carolina is changing the standard that they are applying. We agree with Murdaugh. Prejudice is presumed from Hill's comments. And I said, if the court changes their standard, then there's a new trial. And that's exactly what they're doing. Allie said, does she still have her job? No, she does not still have her job. She resigned because South Carolina did not have any way to impeach her from her elected position. But she stepped down from her position. She got probation. She paid restitution. But she bears the shame of it every day. You can go back and watch me crash out at that hearing after this. The court goes on to say that our federal and state constitutions guarantee a criminal defendant the right to a fair trial by an impartial jury. Yes. They go on to say that no right touches more at the heart of fairness in a trial than the right to an impartial jury. This right can be infringed when a third party makes improper contact with the jury. For the right is meaningful only if the jury remains free from outside influence, including exposure to evidence or information that has not been introduced during the trial. To protect the right to an impartial jury in such cases, the Supreme Court of the United States created a rebuttable presumption of prejudice, elucidating. I never wanted to be an appellate judge. I never wanted to be an appellate lawyer. But damn, I enjoy their writing. I really do. Do I want my entire legal practice to be based on writing briefs? No, I do not. I'm a stand up and talk kind of a girl. This shocks none of you. I'm a trial level lawyer. Love it the most. But damn, I love the writing. I really do enjoy it. Any private communication, contract, or tampering directly or indirectly, this is the standard we're going over, with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial. Talking to the jury about the case is presumed prejudicial because brains. And I talk about this not in the jury sense, but I talk about it in other things. If I sit here and talk about a thing, a fair portion of you are going to go, ooh, that sounds good. Do I need that? If I'm sitting and watching TV, no, let's be accurate. When I'm sitting and watching Ryan Hall, y'all talk about the weather, and he's talking about some, bridge goblin, bridge bandit, whichever phrase he uses, trying to get home with their Wendy's. I'm sitting here going, I might could need a Wendy's. I might could need overpass ogre. Thank you. It was the overpass that I got wrong. I started with the bridge. The overpass ogres. Thank you. He's talking about somebody just trying to get home with their Wendy's before this storm hits. And I'm sitting here going, I might could go for a Wendy's Dr. Pepper. And I know that by saying that, some of you are going to go like, you know what? I might could go for a Wendy's Dr. Pepper myself. Because then it sounds good. And you're like, well, I want the Dr. Pepper, but once you said it, damn, it sounds good. It's really hard to pull back out what influence that has on your brain. This was terrible when I was pregnant, and all of a sudden, all I wanted to eat was Twizzlers. I'm a Red Vines girl. All of a sudden, pregnant, I'm like, damn, I want some Twizzlers. It was a commercial once. And in my brain, I was like, I can't get that out of my brain. It is difficult when something has been suggested to us, and think of this in the context of being a juror. You want to do the right thing. You want to be the right part of the system. But it's back there somewhere in your brain that even the court staff, and don't they watch a lot more trials than you do? Don't they know? Even the court staff thinks he's guilty. So who am I to question them? Right. It's why judges give so many instructions about not commenting on the evidence. Because jurors are looking for certainty. We heard this in the Richens case in the juror interviews to Nate Eaton. That after the trial, they asked Judge M if they did the right thing. Sitting in judgment of someone else is heavy. And it's natural for people to be like, we're right? Like, I think we're right, but we're right? Like, we did the right thing here, right? We check our decisions with each other all the time. And so if in the back of the jurors' minds, well, even the court staff thinks he's guilty, it's a little easier to get to, well, the court staff thinks he's guilty and everybody else in this room thinks he's guilty. It's easier for that one juror to go, well, who am I? Who am I to say that he's not? And so the presumption of prejudice, I think, is the appropriate standard. That's where I'm at on that. Because the defendant is not in the best position to prove the persuasion to the jurors. The state has more power there, so it is on the state to overcome that presumption, and the state has the opportunity to do so in cases. The state has the greater power in this dynamic. It is on them to rebut the presumption, and that can be hard to do. And I think that's appropriate because you have to have a fair and impartial jury. You have to. I think we know where Emily stands on this. Let's continue with the Remmer standard. They go on to say that for obvious reasons, outside interference with the jury is deemed prejudicial if not made in the presence of known rules of the court and instructions and directions of the court made during the trial with full knowledge of the parties. The presumption is not conclusive, but the burden rests heavily upon the government to establish that after notice to and hearing of the defendant, that such contact with the juror was harmless to the defendant. Can it be harmless to the defendant? Yeah, there's times that discussions with the juror could be harmless to the defendant. This is not that time. And we have seen cases with less extreme statements to the jury be overturned in the case law. We go on And they say that the United States Court of Appeals for the Fourth Circuit noted that in addition to the presumption of prejudice, Remmer established a separate but related requirement that the defendant be entitled to a hearing when the defendant presents a credible allegation of communications or contact between a third party and a juror concerning the matter pending before the jury. The Fourth Circuit established a 3-step test. So we've got a standard and now a test, a 3-step test for considering extrajudicial contacts with the jury. The party who is attacking the verdict bears the initial burden of introducing competent evidence that the extrajudicial communications or contacts were more than innocuous interventions. More than don't touch the thermostat, let's get snackies. If this minimal standard is satisfied, the Remmer presumption is triggered automatically. And then almost like in an anti-SLAPP context, you have to get over this first hurdle and then the burden shifts. The defendant has to get over that first hurdle, then you shift into the next part of the burden. The burden then shifts to the prevailing party to prove that there exists no reasonable possibility. That's heavy. No reasonable possibility that the jury's verdict was influenced by an improper communication. That doesn't exist here. There are too many jurors saying the same thing. Reasonable possibility. The Fourth Circuit further provided that in determining whether the extrajudicial contact was innocuous, like you've written this with my least favorite word to pronounce a zillion times. The Fourth Circuit further, God, this thing would be a nightmare to outline. There's a lot of steps to this test. Provided in determining whether the extrajudicial contact was innocuous or whether it triggered the presumption, the court considers whether there was, 1, any private communication. Answer these for yourself as we're going through it. Yeah? We're doing law school tests today. We're doing thought experiment. Based on the facts that we've discussed, answer for yourself. Are these things met? Was there any private communication? Was there any private contact? Was there any tampering? And then you're going to be like, what's the definition of tampering? We'll get there, maybe. Directly or indirectly with a juror about a matter before the jury. Were there communications and contact? Yes. Was it directly with the juror during trial? Yes. Was it about the matter before the jury? Yes. So we are left with, was it tampering? An unauthorized contact between a third party and a juror concerns the matter pending before the jury when it is, here's that definition, quote, of such a character as to reasonably draw into question the integrity of the verdict. Ding, ding. We have that here. Once the Remmer presumption is triggered, the state bears the heavy burden of proving that there is no reasonable possibility that the verdict was affected by the contact. The court must examine the entire picture, including the factual circumstances and the impact on the juror. In determining whether the state met its burden of rebutting the Remmer presumption, courts consider a variety of factors such as, quote, the extent of the improper communication, the extent to which the communication was discussed and considered by the jury, the type of information communicated, the timing of the exposure, and the strength of the state's case. They go on to quote other case law. We're going to take a look at this. Sharon, I know that Alec pronounced it with the Murdaugh at the end. I get it. It's hard for me to say that way. And honestly, I don't really care how Alec pronounces his last name. He also pronounces Alex as Alec. So I do my best. But with Murdaugh, the way my brain reads it is really hard to change to Murdaugh. Truly. At least I call him by his last name and not the abbreviation of his first name. I am going with that. Or I could just start calling him by the abbreviation of his first name. We could do that. It's really hard for my brain. Every time I read it, it's hard for my brain to flip the pronunciation. really, really hard. However, so much easier for me to read when we're in dark mode. So much. That's right. Blue Eyes Fairy in the chat. We should go with Murdaugh. I approve this message. Or Murdacity. We'll go with Murdaugh. Rex888 say, I just hear Murdaugh. No, murder. That's what we need. We need Alan Cumming saying Murdaugh. Yes. Murdaugh. Like a turduncan. We're going with Murdaugh. Murdaugh. The court's going to continue to cite us to case law and other examples. In Parker versus Gladden, the Supreme Court recognized the extreme prejudice inherent in statements concerning the matter at trial when made by an officer of the court. Footnote 6, the Supreme Court did not apply the Remmer analysis in that case in 1966. We've seen this case cited over and over and over again in these arguments. There aren't as many of them. There aren't as many of these cases. I am heartened by the fact that there aren't that many of these cases because everybody knows this is out of bounds. There, they say, a bailiff who oversaw a sequestered jury during an 8-day trial stated to a juror in the presence of other jurors, quote, "Oh, that wicked fellow, he is guilty." Sir, what are we doing? The bailiff also told another juror, if there is anything wrong in finding the defendant guilty, the Supreme Court will correct it. Just convict him. They'll do it. They'll do a doodly boop do-over later. Don't worry about it. At least one juror or alternate overheard the statements. In rejecting the state's argument that no prejudice was shown, the Supreme Court explained that the state's argument overlooks the fact that the official character of the bailiff as an officer of the court, as well as the state, beyond question carries great weight with a jury, which he had been shepherding for 8 days and nights. Although the Supreme Court noted that 26-hour jury deliberations and one juror's testimony that she was prejudiced also supported the trial court's finding, it held that the unauthorized conduct of the bailiff involves such a possibility that prejudice will result that it is deemed inherently lacking in due process. The officers of the court cannot intercede in the jury's deliberations. And Courthouse Becky made herself, at least in her mind, a 13th juror. We did this. We did that. It shouldn't take us long. It further recognized that, quote, it would be blinking reality. It's an interesting turn of phrase. It would be blinking reality not to recognize the extreme prejudice inherent in such statements that reached at least 3 members of the jury and 1 alternate member. However, not all comments by officials of the court are prejudicial. In Green, a juror asked a bailiff, quote, what would happen in the event of a deadlock? And he responded the judge would likely give them an Allen charge and ask if they could stay later. Footnote 7, Allen versus US. We've heard the Allen charge. It's like hey, everybody, no one's coming to save you. Reach a verdict. Consider all options. Listen to everybody. Reach a verdict. Go back there and deliberate more. Try again. My summary of an Allen charge. Called different things in different jurisdictions. While the Court of Appeals held that the state overcame that presumption, this court held that the bailiff's comments did not trigger the presumption. So the comments of a procedural nature, what would happen if we deadlock? Hey, the court's going to tell you more stuff and then ask you to stay more. It is a communication. It is talking about the case that they are in, but it's not the type of communication that is going to trigger that presumption. So there is a balance here. Even though, again, if I was the prosecutor on a case and found out that the bailiff had talked to the jury and answered a question, and that the answer was not, hey, you're going to need to write that down and ask the judge. You're allowed to ask the judge a question. So why don't you write your question down and the judge will answer it for you? Pit in the stomach. That would make me want to barf. No, they fucking didn't. That would make me want to puke. That would stress me out very much. The only correct response to that is, if you have a question for the court, you can write it down. They go on to say that as the Fourth Circuit recognized, there is a split among circuits regarding the issue of whether the Remmer presumption has survived intact following the Supreme Court's decisions in Smith versus Phillips, United States versus Alano, United States versus Lawson. In Phillips, the Supreme Court declined to impute bias to a juror who applied for a job in the prosecutor's office during the trial. What? You were so impressed with the prosecution that you wanted to go work there. That's a problem. I can see why the defense didn't like that. I can see why the defense was like, excuse me, this juror likes the prosecutors so much that they want to go work for them. Y'all hiring? In Phillips, the Supreme Court declined to impute bias to a juror who applied for a job in the prosecutor's office during the Phillips trial. In reversing the grant of federal habeas relief, the Supreme Court declared that the remedy for the allegations of juror partiality is a hearing in which the defendant has an opportunity to prove actual bias. The court explained that due process does not require a new trial every time the juror has been placed in a potentially compromising situation. Instead, due process necessitates a jury capable and willing to decide the case solely on the evidence before it. The footnote to this says that in both Phillips and Alano, the Supreme Court noted that the case's procedural postures informed the outcome. Look, man, process comes first. Process comes first in appeals. If they can answer it based on process, that's going to be the answer. Courts of appeal are going to go to process over facts every single time. And if you have ever wanted to just evaluate the process of how things happen, appellate law may be your favorite shit ever. Trust me. As a research attorney, I went to process all the time. And both of my judges were like, yeah, but I'm not a court of appeals and I still have to deal with this shit. So we need to also get to the facts. And I'm like, but untimely, Your Honor. And the courts are like, adorable. We still have to deal with it. Shit. The appellate court can just kick it out and it goes to somebody else. The trial level court can't. He's like, right. And if we deny it for being untimely, they just have to do it again. So we need to just do it again. Damn it. But I always pointed out the procedural stuff because I was just, well, actually, this should have been double spaced. Stop making it so fucking hard for me to read. Don't piss off the research attorneys. They will read everything with a more critical eye because you've failed to follow local rules. The court goes on to say, also, do you notice how much easier it is for me to read in dark mode? It is so much easier. It is, I wish I could make everything dark mode. I will be trying in the future. I love it so much. In Alano, the Supreme Court considered whether the presence of alternate jurors during jury deliberations was a plain error that the Court of Appeals was authorized to correct under Federal Rule of Criminal Procedure 52B, noting that alternate jurors' presence was not the type of error that affected substantial rights independent of its prejudicial impact. Right, because they're alternates and they're not deliberating. If they're not deliberating, then it doesn't impact the deliberative process the same way. They go on to say, neither Phillips nor Alano expressly overruled the Remmer presumption. Emily, why are we down this rabbit hole of whether this presumption is still alive and well? Because if South Carolina is going to shift the way they evaluate this case under the federal standard, the federal standard still has to be alive and well. And so the question of whether subsequent rulings changed the standard, overruled the standard, eviscerated the standard, have to be evaluated. So the court is saying in these other cases, the reason they didn't apply the standard is not because the standard no longer exists. It's because procedurally it wasn't proper in those cases. So they're evaluating that and then saying, the Fourth Circuit explained that the Remmer presumption applies in cases where, quote, the danger is not one of juror impairment or predisposition, but rather the effect of an extraneous communication upon the deliberative process of the jury. So they are separating the circumstance when this applies. Does this apply in situation A, B, C, D, E? And so they're narrowing this down, I think, pretty succinctly, that the presumption applies where there is an extraneous communication. They go on to say, thus, the distinction between internal and external jury influences is critical because unlike external influences, which necessitate a thorough judicial inquiry, no such obligation is imposed with regard to an internal jury interference. And that is a big deal because you cannot, remember we saw this, I yelled about this in the Reed case. We have seen courts navigate and evaluate whether or not they can intrude upon the deliberative process. And in Murdaugh, they were not asking the jurors specifically and expressly about deliberations. They were asking the jurors about the external communication. Not what did you say in deliberation? What was said to you? And did it impact you? So the internal versus external is a really big difference. Because in the Reed case, the court found that everything that was being discussed was internal. And so the court could not inquire about internal as to whether or not the jury had reached a verdict in the first Reed trial. And so that's the difference here that they are illuminating through other case law. And they're going through a number of other cases and telling you quickly what those cases are about. We're going to keep going. The court goes on to say, our discussion in Green 2 did not deviate from Remmer or its Fourth Circuit progeny. Adhering to Remmer, we held only that the facts of the case did not warrant applying the presumption, while leaving in place the Court of Appeals holding that the trial court must follow the Remmer procedure when it learns of an allegedly improper contact with a juror. Green 2, and then C, e.g. Green 1. The Fourth Circuit, they say, has long, and that's the controlling circuit here, the Fourth Circuit, they say, has long recognized that certain kinds of extrajudicial contacts may amount to nothing more than innocuous interventions that simply could not justify a presumption of prejudicial effect. They go on to say that we acknowledge that this court has not always employed the Remmer presumption. And that's the issue, right? That is the issue. That is the issue that Justice Toll was struggling with. Eyeglass Train of Mind said, this is so interesting. It's not unlike mathematical proofing. A great analogy. And this is where a lot of law school is spent. So if you've ever argued with an attorney and you're like, this is like splitting hairs, this is what we spend a lot of time in law school evaluating. Picking apart the nuance of, does the court mean this or this? Does the comma change the phrase? You wrote, my dearest Angelica. This is where the thought process of if this, then that, then that, then that, but if this, then that, then that, then that starts in law school. But here the court did this, but here the court did that. But what about over here? Then they did something different. What are the facts? Where is it different? Where is it the same? What did the judges that came before said? What did they say? What does the dissent say? What does the concurrence say? This is where the nuance of law lives. So, we acknowledge that this court has not always employed the Remmer presumption. We are sorry that we made a mess. Our bad. We understand that that this makes it really hard for future courts to apply a standard because we have not applied it consistently. Right. It's like if you're in high school and your teacher's like, hey, you guys can use your cell phones in class. And then one day your teacher's like, why the fuck do you all have your cell phones out in class? It's like, excuse me. You said it was like fine. So we're like going based on what you've been doing. So the Supreme Court is acknowledging that they have not been consistent. Right. Which leaves Justice Toll with the Supreme Court has not applied the Remmer standard. And because of that, I am not applying the Remmer standard. So if the Supreme Court wants it applied, then they need to come out and say it. And they said, bet. And now we're here. In Kelly, an appellant asserted the trial court erred in denying his motion for mistrial when a capital case juror shared a pro-death penalty pamphlet in the jury room during the penalty phase of the trial. Internal interference. Also, what the fuck? What the fuck is this juror doing? Because the appellant framed the issue on appeal as the denial of a mistrial. See the difference? That was the denial of a mistrial, not the denial of a motion for new trial. Those things are procedurally different. The court noted that in order to receive a mistrial, the defendant must show error and resulting prejudice. We held that the appellant failed to show prejudice. We did not discuss Remmer. So the Supreme Court is clarifying the differences procedurally in a motion for mistrial and denial of a mistrial and an appeal of that versus a motion for new trial and an appeal of that. We also have a difference between external and internal influence because this is a juror attempting to influence other jurors. And so that came up in the oral arguments as well. They are going on to go through, and I will post this and post the link to the South Carolina Supreme Court if you want to download it directly from the court's website. I will post this if you want to read paragraph by paragraph. The court goes on to line out other times they have not applied the standard and distinguish them. And then they get to the new law part. We clarify today. This is where this goes forward. We clarify today that when faced with a third party's improper contact with a juror, our courts should follow the Fourth Circuit's 3-step analysis as set forth in Cheek. That is the new standard. That is a clarification of this is a new standard. And then they lay out the 3-step analysis from their Cheek case. 1, require the defendant to meet the initial burden by presenting evidence that contacts were, quote, more than innocuous interventions. 2, if this minimal standard is satisfied, recognize that the Remmer presumption is triggered automatically. 3, shift the burden to the prevailing party, the state, to prove that there exists no reasonable possibility that the jury's verdict was influenced by an improper communication. Once Remmer is triggered, it is incredibly difficult. This is me interjecting. It is incredibly difficult for the state to prove that there is no reasonable possibility that a jury's verdict was influenced. That becomes difficult. They go on to say that under the framework, we turn to the facts at hand. So they gave us the facts, because the writing is glorious, the facts, the lay of the land with the case law, kind of the road so far of the case law, They acknowledged that they have not always been crispy clear in their case law, and they clean it up. Hey, we are stating unequivocally that this is what applies, which means if there is a case that comes up in the future where the concern is third-party external interference with the jury, this is the case that is going to be cited. So I guess as a lawyer, Murdaugh has left his mark on the profession. Not the way most lawyers hope. But this is going to be standing case law in South Carolina for decades, if not centuries to come. So, well done, everybody. You will go down in infamy. And create new case law while you're at it. Huzzah. Under this framework, and now they're going to apply it. So we got the facts, we got the law road so far, we got what the law should be now in South Carolina that's going to align with the Fourth Circuit. And now we are applying those facts to this law in practice. Now, what are the things? Under this framework, we turn to the facts at hand. First, we must determine which comments Hill made to the jurors. The post-trial court referenced only a few of the comments the jurors testified that she made, e.g., "This is an important day. This is an epic day. Watch his body language." The state argues the post-trial court implicitly rejected the other alleged comments as not being credible. We find this argument is without merit. Murdaugh said, can this case law be used in any other states or only South Carolina? Murdaugh, this is binding law for South Carolina. The South Carolina Supreme Court does not bind any other jurisdiction. However, most courts of appeal already apply this standard. South Carolina is catching up to the larger weight of the evidence out there, which means every other jurisdiction under the Fourth Circuit, if they aren't already applying this, have the opportunity to shift to adhere to the Fourth Circuit. And lots of other jurisdictions already apply the Remmer standard in their own ways. But no, South Carolina Supreme Court case law is not binding on any other jurisdiction. The Fourth Circuit is on other states within the jurisdiction. It's complex. We have a lot of courts in the U.S. We got a lot of courts in the U.S. And how they all play together is something I'm always happy to chat about. So thank you for asking. It goes on to say that the post-trial court, this is Justice Toll, gave no indication it found the other comments not credible, nor would the record suggest or support such a finding. Indeed, the post-trial court found Hill's denial of making any inappropriate comments lacks credibility. So they are now interpreting what Justice Toll meant with Justice Toll's statements and ruling. Did Justice Toll find that the other statements weren't credible, or did she find that Hill was not credible? And they are saying she found that Hill was not credible. So, footnote 10. Actually, let's just go to footnote 10. Footnote 10 goes to that the post-trial court found that Hill's denial of making any inappropriate comments lacked credibility. Footnote 10. Hill's lack of credibility during the hearing on Murdaugh's motion for new trial is further evidenced by her recent guilty plea to perjury, stemming from that very hearing for her denial of allowing members of the press to view sealed exhibits. Perjury. The post-trial court, they go on to say, made no distinction regarding the comments it referenced in its order and found, and the remaining comments that are in the record. The post-trial court, in fact, found credible Juror Z's statement concerning pressure from other jurors. The same affidavit included Juror Z's recollection of Hill's comments, quote, not to be fooled by the evidence presented by Murdaugh's attorneys, and Hill's instructions to, quote, Watch Murdaugh closely. Look at his actions. Look at his movements. The state offers no rationale for finding part of the affidavit credible while rejecting the other portions that are damaging to the state's case. Well, they got to argue something, Your Honor. I guess they got to argue something. They got to argue something. They got to argue something. They can't just say, nah. Riley asked, I wonder if the ruling would be the same if there was no perjury charge on Hill. Yes. I think so. Because the perjury is sprinkles. Justice Toll's finding is what they are relying on. The perjury is sprinkles to what Justice Toll found, but they're relying on what Justice Toll found. Justice Toll found that Becky was not credible, even before they went and proved the perjury. So yeah, it would have been the same. Hopefully that makes sense. They go on to say that the state offers no rationale for finding part of the affidavit credible while rejecting the portions that are damaging to their case. Juror Z's recollections of Hill's comments was inconsistent with Juror 785's affidavit testimony that Hill told jurors not to be fooled by the evidence Murdaugh's defense presented. Juror Z's recollections, Juror Z's recollection is also consistent with the alternate juror's testimony concerning Hill's comments. Quote, they're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. These comments were also strikingly similar to comments Hill made to McElveen. Ding, ding, ding. Other staff members and media went away from the jury, and that's what it is. Just a Test 90 said, I don't get why Toll wasn't already bound by the SCOTUS decision in Remmer, because that is a federal decision. The South Carolina Supreme Court had not applied it consistently in all cases. South Carolina can interpret how they test for whether or not external influence prejudices the jury, separate from how the federal government or the federal court system does. So it's not binding. Justice Toll was going with the case law from South Carolina and the history from the South Carolina Supreme Court. You can end up with splits in how things are applied, especially when it comes to how they test for something. They go on to say, let's see, I lost my place a little bit. They go on to say, there we go. Juror Z's recollection is also consistent with the alternate juror's testimony. Don't let them confuse you or throw you off. Footnote 11. These comments were also strikingly similar to the comments Hill made to McElveen. And that's a huge part of this, right? That this is not just what it was said to the jurors, but that it is also echoed by McElveen, who was incredibly credible and consistent. Footnote 11 says the post-trial court did not make a finding on the alternate juror's credibility. The Supreme Court goes on to say further, and this is for everybody just popping in, South Carolina Supreme Court. The Supreme Court goes on to say that Hill's attempt to insert herself into the jury's deliberations through these comments was in line with her stated desire for a guilty verdict to sell more copies of the book she planned to write. Her meddling in events around Juror 785's dismissal and her self-aggrandizing conduct throughout and after the trial, from granting favors to members of the media, such as allowing them to view sealed exhibits and sitting a writer with court staff in the courtroom to granting interviews. As the post-trial court found, Hill was attracted by the siren call of celebrity and allowed her desire for public attention of the moment to overcome her duty to her oath and her office. Well, ma'am, you've got public attention now. I guess be careful what you wish for. but I'm kind of dying that the South Carolina Supreme Court said meddling. It's appropriate and I love it. Her meddling in events and her self-aggrandizing conduct. They're calling out fuckery for the siren song of celebrity. The problem is celebrity and infamy are not the same. And Becky Hill is going to find that infamy is not what she wants. Gamma asked, oh my goodness. So her tampering with the jury will cause a retrial. Yes. What are the consequences for her? None. Will she have to cover the cost of the first trial? No. She should. But no. They did not prosecute her for jury tampering. And the standard for jury tampering criminally is different than the standard that the Supreme Court is applying here. I don't like that result either. I don't like that they chose not to prosecute her for jury tampering. But if they had, you could end up with the result that they prosecuted her and lost for jury tampering, but that this still stands. Because the standards are different. Here, it's presumed that it's fuckery. If you prosecute her, you have to show beyond a reasonable doubt that she was tampering with the jury. And for whatever reason, they chose not to. I worry, and this is my worry. This is my worry plus side eye, I suppose. I worry that prosecuting her for jury tampering while this was still pending to the Supreme Court would be perceived by those choosing to prosecute Courthouse Becky as an acquiescence that she did, in fact, tamper with the jury, because the state has been arguing that she didn't tamper with the jury. So you could end up with judicial estoppel, I think, because you can't have the AG's office go and argue this to the Supreme Court of the state and say she didn't impact the jury and then also turn around and prosecute her for jury tampering. Those two arguments cannot exist in court. They could have prosecuted her for jury tampering and abandoned that argument at the state Supreme Court, but then you've abandoned your argument and Alec Murdaugh gets a new trial, period. I worry. And they appointed an independent prosecutor to evaluate this, but they could not charge her with jury tampering and then go argue that she didn't impact the jury. That. Can't do that. And they argued all the way up to the Supreme Court that this did not influence the jury. The Supreme Court finds, well, we'll continue to see what they find. They find that the Remmer presumption applies. They find that the Remmer presumption applies, and we are walking through that. But if you want to see what the independent prosecutor said about not charging Courthouse Becky with perjury, it's in that hearing that'll be linked below. But yeah, there is a judicial estoppel problem for them if they did prosecute her. They go on to say, we have no reason to find that Hill did not make all of the statements the jurors reported. Therefore, we hold that Murdaugh established Hill made comments that the day Murdaugh testified was going to be epic or important, and urged jurors not to be fooled, confused, thrown off, or convinced by Murdaugh, and to watch Murdaugh's body language closely. The Supreme Court finds that Courthouse Becky told the jurors to disregard the defense. You cannot do that. That is jury tampering. That prejudices a jury. You cannot tell a jury to disregard the defense. And I think there were times when Poot was pooting around the courtroom that the jury can look at that themselves and be like, really? The jury can determine it for themselves. The Supreme Court goes on to say, next, we must decide whether these comments were, quote, more than innocuous interventions. And then they go on to cite the case law that we've talked about. I'm going to go past the case law citations into their application of the facts. The Supreme Court here says, Hill became a character witness on behalf of the state, encouraging the jurors to question Murdaugh's credibility. And that is the final nail in what they're going to decide. Right there. Hill became a character witness on behalf of the state. In fact, by urging the jurors not to be fooled or convinced by Murdaugh's defense, Hill essentially implored the jurors to find him guilty, the ultimate issue in the case. Even Hill's seemingly innocuous comments that the day Murdaugh testified was epic or important.
Oh my God, you guys. Epic day. All eyes on me in the center of a ring just like a circus. Yeah. Becky Hill was rolling up in court being like, it's Brittany, bitch. Nope. Can't do that. Can't do that. What the fuck? Today's gonna be epic. It's so important.
Ugh. Even Hill's seemingly innocuous comments that the day Murdaugh testified was an epic or important day became nefarious when considered with her other comments. Oh, I'm sorry. We're in South Carolina. Can we go to Massachusetts for a second? Nefarious. It's like Dr. Nefario. It became nefarious when considered with her other comments, insinuating that there was something unusual or suspicious about his decision to testify. In contrast, the bailiff's statements in Green, though improper, did not touch the merits, but they only dealt with the procedural question of how the judge might handle a jury impasse. Therefore, we hold that Murdaugh met the minimal standard showing that the extrajudicial communications or contacts were more than innocuous interventions. This goes to the heart of the case. And the post-trial court erred as a matter of law in refusing to impose the Remmer presumption. Our following consideration is whether the state met its heavy burden. How many times have they said heavy burden? They're signaling exactly where they're going to go. I mean, they tell you at the beginning, but they signal that the state could not carry this burden and that this is not an easy hurdle to overcome. They have to determine whether the state met their burden of proving that there was no reasonable possibility that the verdict was affected by Hill's comments. As stated below, the post-trial court analyzed the evidence before it erroneously imposed the burden of proof on Murdaugh. Furthermore, as Murdaugh argues, the post-trial court erred in considering testimony from the jurors about whether Hill's comments affected their verdict, because this testimony violated Rule 606B of the South Carolina Rules of Evidence. And then they cite the Rule 606B and go on to say, in interpreting court rules, this court applies the same rules of construction used to interpret statutes. If the rule's language is plain, unambiguous, and conveys a clear meaning, interpretation is unnecessary, and the stated meaning should be enforced. They go on to cite the Supreme Court's and the way the Supreme Court interprets the rules. I'm getting to their interpretation. We're going to skip some of their delineation of the rules because for this point, it does not change things as much for us as them changing the Remmer standard. They go on to say that they find that the plain language of Rule 606B authorizes jurors to testify about improper extraneous comments by a third party, but not on the comments effects of the juror's deliberative process. Right. The state contends that Murdaugh cannot complain about the post-trial court questioning Juror Z regarding her affidavit because Murdaugh submitted the affidavit to its post-trial court with his motion for new trial. They say that the right was not Murdaugh's to waive. Thus, the portion of Juror Z's affidavit in which she disclosed her mental process in reaching her verdict was inadmissible. The post-trial court erred in questioning her about that portion of the affidavit. So, where are we now? Well, when Juror Z was questioned about whether Becky Hill's statement or the other jurors was more persuasive, the court is saying, back that thing up. That's questioning the deliberative process. This gets us back to where Massachusetts was in Reed 1. You cannot ask a juror about the deliberative process, and asking the juror if Hill's comments or the other jurors' conversations was more impactful on them violates the province of deliberations, and therefore that part is yeeted. Yeet. That is none shall pass. So the juror saying in court that they were more influenced by other jurors is stripped out of this. What stands then is the juror saying that Becky Hill influenced their verdict. The rest of it is pulled out. Does that make sense? The court goes on to say that the post-trial court erred in questioning her about that portion of the affidavit, and the post-trial court should not have considered that portion in ruling on the new trial motion. So that part has been removed. If you are curious about questioning jurors about deliberation, when you read this, go back to those parts. We went over the recitation of case law in that pretty quickly because I think we've covered it in other court rulings in other cases, but that's where it lives after they get to talking about changing the standard. We also hold that the post-trial court erred in finding a lack of prejudice because Hill's comments were limited in subject and not overt as to opinion, were only heard by at most 3 jurors, and were made in a case with overwhelming and compelling evidence. We reiterate the burden is on the state to rebut the presumption of prejudice. So they're saying to the trial court, you did not apply the right standard. And because you didn't apply the right standard, we are now reevaluating it under the standard that we think should have been applied. Hill clearly advised the jurors to find Murdaugh and the evidence he presented not credible and essentially urged them to render a guilty verdict. Bad on Becky, because the Supreme Court of South Carolina said you were fucking around, and now, well, all of us are finding out, and the taxpayers of South Carolina are finding out. They find that she advised the jurors to find him guilty. Hill's position as the clerk of court, an officer of the court who managed the trial and was the primary caretaker of the jury, amplified the impact her comments had on the jury. Right. She is in a position of trust. They go on to say Hill was elected by the very people who make up the Colton County jury pool. She was in a position of trust, and she violated that trust. I mean, she was also taking money from them. That was part of her plea as well. In addition to lying to Justice Toll, clerk of court, engaging in fucking perjury and letting people see sealed exhibits of the victims. It's appalling. They go on to say next, the limited number of jurors who acknowledged hearing Hill's improper comments did not reduce the prejudicial effect. As the Supreme Court explained, a criminal defendant is entitled to be tried by 12, not 9 or even 10, impartial and unprejudiced jurors. If there is one, it violates the Constitution. That is what they are saying. In addition, in the context of a jury tainted by external influences, the strength of the state's case does not necessarily warrant a finding that the state met its burden of proving a lack of prejudice. It doesn't matter how strong the case is. It doesn't matter. This could be a trial, not this trial. This could be a trial with a crime on video and a signed confession. If this happened, a new trial would still happen. Because you still have a prejudiced jury pool. Now, if it's on video and if there's a signed confession, maybe the state can overcome the presumption. But the court is indicating that it's unlikely because of the position of trust and what was said. Don't worry. I've seen a couple of you ask about double jeopardy. I had said earlier in stream that we will talk about it at the end of the hearing. Don't worry. Or at the end of the ruling. We will come back to it at the end of the ruling. In addition, in the context of a jury tainted by external influences, the strength of the state's case does not necessarily warrant a finding that the state met its burden. The state certainly produced considerable evidence here. And arguably, reasonable minds may debate. Shout out to Rick Hogue from the South Carolina Supreme Court. Reasonable minds may debate whether the evidence here was overwhelming. In the situation before us, notwithstanding the strength of the prosecution's case, the state is unable to overcome the presumption of prejudice. The state's case rested largely on circumstantial evidence. Oh, yeah, this was a circumstantial evidence case. This is a circumstantial evidence case. And Murdaugh's credibility was a key component of his defense. I agree. And his credibility and the evaluation of his credibility was tainted by the clerk, former clerk. Hill's repeated comments challenging Murdaugh's credibility directly undermined that defense. Hill's egregious, improper jury interference went to the heart of the case and unquestionably was intended to push the jury to a guilty verdict. And now she has undone all of it. I Am Heather asked, can Courthouse Becky not be held financially liable for paying for a portion of the next trial? No, she can't be. There is not a mechanism under the law to do that. Though, I would be fascinated in the experiment of whether or not the taxpayers of South Carolina could sue her for the cost, as like a taxpayer coalition, for the cost of the trial, like the past trial. So sue her for the cost of the past trial, not the retrial. And whether or not there would be any privilege that would protect the office of the clerk of court from this type of impropriety. because I wonder if the taxpayers could consider that. I do not know what type of privilege might extend to a clerk of court in this circumstance, but I'd be interested if any South Carolina attorneys have any input on that. I am dead curious. There was restitution in her plea, but remember, the restitution went directly to the money that she stole from the county. It did not go to the cost of this because she was not prosecuted for jury tampering. So could there be a civil lawsuit against her on behalf of the taxpayers? Maybe. I don't think they would be more. This is a great question, chat, and I'm going to try to get through this. Jenna said, wouldn't they be more entitled to the cost of the retrial? No, because the retrial is essentially the first trial. The trial that she fucked up is the one that got overturned. Her actions cost that trial. Also, I suspect that the first trial will be more expensive than the second because the evidence is going to be narrowed down. So I suspect the trial that she fucked up is the one that got overturned. That's the one she should pay for. And then the county can pay for the trial on take two. Or the state can pay for take two. So I'm curious. We'll see. I have questions. Because if she hadn't done this, the conviction would just stand. This trial, she messed up. Let's see. They are evaluating the strength of the case. They called Hill's behavior egregious. They go on to say that they cite some case law regarding that and say the breathtaking and disgraceful effort of Hill to undermine the jury process is unprecedented in South Carolina. Well, chat, she excels at something. The South Carolina Supreme Court has continued to find new ways to say, Courthouse Becky, you done fucked up. They have said that it is breathtaking and disgraceful, egregious, nefarious. They have found all of the words. The breathtaking and disgraceful effort of Hill to undermine the jury process is unprecedented in South Carolina. I can't imagine being a law student, reading this case and not wanting to go back and just binge watch the entire trial and the FOIA of the emails. This would send me on a rabbit hole for a couple of months, for sure. I'd be like, I need the emails. I need the trial. I need to see everything. I need to see everything. They go on to say, finally, we hold that the state has not met its burden of proving that the trial court's instructions to the jury cured any prejudice from Hill's comments. They go on to say that the trial court gave the standard instructions and admonitions to the jury, none of which provided guidance on what to do when the Colton County Clerk of Court, former Clerk of Court, Courthouse Becky, an officer of the court, made comments disparaging Murdaugh's credibility and urging the jury to reject his defense. The trial court never had the opportunity to even attempt to cure the prejudicial effect of Hill's comments because they did not come to light until months after the trial. There is nothing Judge Newman could have done because Newman didn't know. So the jury instructions can't cure an ill that it is unaware of. Newman didn't know. Newman didn't know. Newman didn't know. Don't tell Newman. If they go on to say we are to accept the proposition that standard charges could cure such prejudice, then no defendant would be entitled to relief when improper extrajudicial information reaches the jury's ears, regardless of its content or context. Our federal and state constitutions simply cannot countenance such an assault on the right to a fair and impartial jury. Damn, they have strong feelings about this. And I get it. The fuckery is strong. I get it. In summation, Murdaugh's met his initial burden in establishing Hill's comments to the jury were more than innocuous interventions, triggering the Remmer presumption of prejudice and shifting the burden to the state. The state simply was unable to meet this heavy burden of proving that there exists no reasonable possibility that the jury's verdict was influenced by these highly improper comments. Accordingly, we hold that Murdaugh's right to a fair trial by an impartial jury was violated, and the post-trial court erred in denying his motion for new trial. Done.
Mention it all. Mention it all.
Done. There's nothing else to do. Evidence of Murdaugh's financial crimes. We talked about this a lot. We talked about the boundaries of how much you can admit, how much you can't admit. We need more lip gloss for this. Yeah, we do. How much can be admitted or not? When is motive evidence crossing the boundary of more prejudicial than probative? It's something we talked about during trial. It's something the defense talked about during trial. It's something that we talked about with boundaries. There are boundaries to this. And this is one of the areas that you can see cases getting overturned on when too much prejudicial information is allowed in. And as we were going through this trial, a lot came in. And there were times that it felt like we had slipped into a second trial within a trial. And the court is commenting on that because it was one of the areas that were brought up on appeal. The court says, because we order a new trial on the basis of Hill's improper influence on the jury on appeal from an order denying Murdaugh's motion for new trial, it is not necessary that we address the evidentiary issues Murdaugh raises on appeal from his convictions and sentences. We elect, however, to offer the trial court on remand the following guidance regarding the admissibility of evidence of Murdaugh's financial crimes. We don't have to talk about this, but we think we should. When a Supreme Court or Court of Appeal feels the need to offer guidance, it's because they are deeply concerned. They are deeply concerned about the evidence. Footnote 13. Oh, that's an extensive footnote. Oh my. This is a big footnote. Averil's Hobby Channel said, however, since we gave this shit some serious side eye, yes. In addition to Murdaugh's challenge to the trial court's decision to admit evidence of his financial crimes, Murdaugh appealed the trial court's decision to 1. Allow the state to question a witness on redirect examination about the witness's knowledge of Murdaugh's financial situation. 2, admit evidence of firearm and toolmark analysis expert testimony. 3, admit evidence of 4 firearms seized from Moselle, which Poot waved around the courtroom in a way that made me deeply uncomfortable. 4, admit evidence of a blue raincoat collected from the home of, I forgot about that, collected from the home of Murdaugh's mother and gunshot residue expert testimony related to that raincoat. 5, allowed the state to question Murdaugh on cross-examination as to the reasons he did not reveal until trial his presence at the kennels on the night of the murders. This is similar to, that point is similar to the argument we are seeing from Banfield in his motion for new trial that we will see at the beginning of June on oral argument. 6, admit evidence of an iPhone demonstration during the state's rebuttal case. That shit was wild. That shit was wild. Yep. That the phone, don't do that again. Don't do that again. That the throwing the fucking phone around the office was wild work. I was stunned that came in at trial. What are we doing? Oh, here we go. Okay. Here we go. Don't do that again. Ever. I never want to see that again in court. I mean, the coroner armpits I thought was going to be the weirdest thing we saw in court, and then we got to the phone being thrown around, and that shit was crazy. At the time of trial, Murdaugh had been accused of and indicted of numerous financial crimes. During his testimony before the jury, Murdaugh admitted he had committed the financial crimes, although he had not at that time been convicted of anything. After trial, he pled guilty to the financial crimes in both state and federal court. He was sentenced to a concurrent 27 years in prison and 40 years in federal prison. The state sought to admit evidence of those financial crimes during the murder trial for the purpose of showing his motive for committing the murders. And we just saw that in Richens. We saw evidence of financial crimes as motive, and it was greatly pared down from what exists in the world of Corey Richens. This was not greatly pared down in any way. This was a concerning amount, I think, for everybody. And Murdaugh got up there and was like, yeah, I did it. But at some point, where do we cross over that it just makes you fucking hate him more than it helps you determine if he committed a murder? So when we're thinking about more prejudicial than probative, does it help you figure out if dude committed murder, or does it just make you hate dude? If it just makes you hate dude, we've crossed the boundary. We talked about that with the Corey Richens throat punching her sister-in-law. It just makes you fucking hate her. It doesn't really help you figure out if she committed a murder or not. So, the state sought to admit evidence of the financial crimes during the trial for the purpose of showing motive. The state filed a pretrial motion in which it argued the evidence demonstrated that Murdaugh accrued substantial debts over a period of years, and to cover those debts, began engaging in illicit financial crimes involving the theft and misappropriation of money from his clients and his own firm. And fake forge! That was my insertion. The state emphasized that several series of events unfolding in the weeks and days leading up to the murders threatened to expose Murdaugh's financial crimes. The state wrote in its motion, all of these factors start to converge on June 7th, 2021, the date of the murders. The state explained its motive theory that the murders served as Murdaugh's means to shift the focus away from himself and buy himself some additional time to try to prevent the financial crimes from being uncovered. The state also stressed Murdaugh's attempts to cover his financial misdeeds after the murders to support its theory of motive. Murdaugh filed his motions. The trial court conducted a lengthy pretrial hearing, but declined to rule on the admissibility of the financial crimes evidence at that time. During various breaks in the course of the trial, the state presented the testimony of 8 witnesses. Do you remember how many voir dires we did? So many voir dires outside the presence of the jury. So much testimony outside the presence of the jury. So many times, chat was just like, hey, didn't we already hear this? Yeah, we did, but the jury didn't. 6 weeks of trial. Almost 7 weeks of trial. It was supposed to be a 3-week trial. After hearing this testimony and the arguments of both sides, the trial court found all evidence of financial crimes that may likely have led to a motive or lend itself to motive was admissible. The trial court stated that the jury was entitled to consider whether the apparent desperation of Mr. Murdaugh because of his financially dire situation, I messed those words up in order, but same, threat of being exposed for committing the crimes for which he was later charged, resulted in the commission of the alleged crimes. The trial court also found this evidence of other crimes is admissible, and its non-propensity, which means it does not go to, hey, fuck this dude. It goes to, hey, is that motive? As it does not suggest to the jury that the defendant has a tendency to commit murder. So it's not like, oh, he's a murdering murder that murders. I specifically find that these other crimes will not lure the jury into declaring guilt on the defendant on the ground, on a different ground than that specific charge. But at some point that can be too much, is the problem. The trial court found the evidence, had sufficient probative value and was not substantially outweighed by any danger of unfair prejudice. The trial court issued a written order setting forth its ruling. The state then presented testimony to the jury of the 8 witnesses who testified earlier, along with 2 additional witnesses. 10 witnesses about financial fuckery. Some of them deeply, deeply sympathetic. The things that Murdaugh did to his own clients is abhorrent. But that's kind of the problem. Footnote 14. Oh gosh, this is a long footnote. The 8 witnesses who testified outside the jury's presence were Jeannie Seckinger. That witness was fucking great, and I think that witness testifies again. I think Seckinger testifies again. I think that was a great motive witness. Absolutely. Jeannie Seckinger, the chief financial officer of Murdaugh's law firm. Michael Gunn, a principal in Forge Consulting, LLC. I think fake Forge happens again. Attorney Chris Wilson, I think probably. Murdaugh's friend and his co-counsel in several cases. Jane Malowinski, who succeeded Russell Lafitte, Murdaugh's co-defendant and co-conspirator in the financial crimes as president of Palmetto State Bank. I think that might come in as well. Michael Tony Satterfield, the son of Murdaugh's former housekeeper, Gloria Satterfield. That might not come in the entirety that it came in trial the next go round. Carson Burney, a forensic accountant in the Attorney General's office, maybe. Attorney Mark Tinsley, Murdaugh's former friend and opposing counsel in a civil lawsuit involving a 2019 boat wreck. That might come in a modified way, in which Murdaugh was personally named as a defendant. Attorney Ronnie Crosby, Murdaugh's former law partner. The additional witnesses were Annette Griswold, Murdaugh's former paralegal, and Natasha Moody, a consumer resolution associate at Bank of America. They go on to say that through these witnesses, the state proved Murdaugh committed wide-ranging financial crimes over numerous years in several general categories, including the following. 1, he stole money from his clients by billing personal expenses to them under the guise of those expenses being costs associated with their cases. How very Girardi of you. 2, he stole money from his law firm by instructing law firm employees to make checks payable to Palmetto State Bank, whose then chief executive officer, Russell Lafitte, enabled Murdaugh to convert the funds for his personal use. 3, and Lafitte was prosecuted federally. 3, Murdaugh stole money from his clients and his law firm by instructing law firm employees to make checks payable to Forge, a fake account Murdaugh created to imitate the legitimate Forge accounts. Yeah, fake Forge. Murdaugh then deposited and used those for personal funds. They were supposed to be trust accounts for the clients. 4, he stole money from Tony Satterfield by filing an insurance claim in relation to his mother, Gloria Satterfield's death, and collecting the insurance proceeds for personal use instead of proving or providing the proceeds to Tony and Gloria's older son. I think that if it comes in again would be heavily sanitized, because I think that the Satterfield case is part of the gathering storm, but I think forensic accountants can cover that. The state also presented evidence to the jury that Murdaugh's years of stealing money in these ways was about to be exposed. For example, law firm employees testified they asked Murdaugh on at least 2 occasions in the weeks leading up to the murders about discrepancies in his financial disbursement documents in individual cases. I think Seckinger testifies again. I'm curious what the court says I don't know what they're going to say. We'll see. Jeannie Seconder, the firm's chief financial officer, testified she confronted Murdaugh on the morning of the murders, stating, quote, "I have reason to believe that you received attorney's fees in certain cases directly to you, and you need to prove to me that you did not." Other evidence indicated that Seconder was referring to $792,000 in missing attorney's fees that the firm was supposed to receive from Murdaugh's co-counsel, Chris Wilson. The state also presented evidence that Mark Tinsley, the attorney representing the family of the young woman who died in the boat wreck, Mallory Beach, had scheduled a motion hearing for 3 days after the murders in which Tinsley sought to compel Murdaugh to disclose his detailed financial records. This was the gathering storm that they were talking about. Murdaugh goes on to challenge the admissibility under the rules of evidence. I'm not going to go through each of the rules of evidence. Let's see where the court jumps back in. We agree with the state that evidence of Murdaugh's financial crimes made the state's theory of motive more probable. Thus, we find that the trial court acted within its discretion in finding the financial crimes evidence was relevant and admissible. The more difficult question is whether the trial court should have excluded all or some of the financial crimes evidence pursuant to 404B or 403. We address this question in two distinct categories of issues. They're doing a full ruling on this too. This is not just a side comment. This is a, hey, is this more prejudicial? We have thoughts. 404, should the evidence be not found? The first of these categories, whether the trial court should have excluded all of the financial crimes evidence, is a point on which not all members of the court would have ruled the same way had we been the trial court. We each agree, however, this was a decision within the discretion of the trial court under the facts and circumstances that existed. As to the second category, so they punted that. They're not unanimous, so they sidestepped it. As to the second category, we will address whether the trial court should have restricted. Lucy, it's a great question. I'm going to hold it till we get to the end of the opinion. I just wanted to let you know I saw it. I'm going to hold that. As the second category, we will address whether the trial court should have restricted the extent to which the state was allowed to present this evidence. That is, whether the trial court should have excluded some of the evidence. We unanimously hold that the trial court allowed the state to go far too long and far too deep into aspects of Murdaugh's financial crimes that were not probative of the state's theory of motive. Because we're in too deep. We've gone full sum 41. Well done, Supreme Court of South Carolina. Because I'm in too... Yes, full sum 41. In too deep. They allowed too much in, according to the Supreme Court. We unanimously hold that the trial court allowed the state to go far too long and far too deep into aspects of Murdaugh's financial crimes that were not probative of the state's theory of motive, which gave rise to considerable danger of unfair prejudice and therefore should have been excluded. Too much. As to whether the trial court should have excluded all evidence of Murdaugh's financial crimes under Rules 403 or 404, we have discussed the principles applicable, which means and they are not going to further elaborate on that. As to Rule 404B, the difficulty lies in the application of those principles to the facts and circumstances of any individual case. Here, the trial court correctly understood the applicable principles of the law and thoughtfully applied those principles to the facts and circumstances before it. The trial court explained its views of the logical connection between the financial crimes and Murdaugh's motive. The state's argument that it presented a valid theory of motive and Murdaugh's response that the fabricated motive theory is illogical, implausible, and not supported by the evidence was not a dispute for the trial court to resolve by making this evidentiary ruling. That was for the jury. The trial court's job was to determine in its discretion whether the state's theory of motive was reasonably plausible, and if so, whether the evidence the state presented could reasonably support the theory. We agree with the state that under the facts and circumstances in the existence in Murdaugh's first trial, the trial court acted within its discretion in deciding not to exclude the evidence. It's admissible. As to 403, the trial court balanced the probative value of the evidence against its potential for unfair prejudice and concluded the probative value was not substantially outweighed by the unfair prejudice. Again, probative value. Does it help the jury determine whether the person did the thing they're charged with? Unfair prejudice. Does it make you just hate the person? Do you just look at them and go, you suck? If you just look at them and go, you suck, and it doesn't help you determine if the crime happened, then more prejudicial than probative. The Corey Richins case has a lot of great examples of this. The way that the walk the dog letter was parsed for the jury is the way courts should narrow down evidence that can be more prejudicial than probative. Within that walk the dog letter, Corey's creating and concocting this entire story that her brother's going to go tell her lawyer so her lawyer can call the brother to testify and give all this bullshit that didn't actually happen. But the second part of the walk the dog letter is the let's get those bitches. It's Corey saying that if her family was to just leak her niece's photos to the media, that would go after her sister-in-law. That doesn't help us decide if Corey's a murderer or not. It helps you decide if Corey's an asshole or not. It just makes you hate Corey because who the fuck does that? But it doesn't help you decide the murder of Eric Richins. Her concocting a story after the event, going wink, wink, nod, nod, this is what happened, is consciousness of guilt. That helps you decide the murder. So that's where we're at, because that's where the court has to balance this. There was a comment in the chat that Sammy D said, you playing the tiny violin during Becca Boo's please statement lives rent free in my head. It was deserved. So they go on to say that the trial court specifically found that the commission of the financial crimes does not suggest to the jury that the defendant has a tendency to commit murder. That goes to whether or not it just tries to say, well, because he's committing these crimes, he's committing murder. They have to get past that. However, we hold that the trial court acted within its discretion in admitting some evidence of the financial crimes. Again, just not too much. We emphasize, however, the trial court should have limited the state's presentation of this evidence. We illustrate this point with an example from the direct examination of Tony Satterfield. Okay, this makes sense that they're bringing up Tony Satterfield. It was the most sympathetic witness. And with it being the most sympathetic witness, it also has the largest potential to prejudice the jury without helping them decide if he's a murderer. State, why were you the personal representative and not your brother? Satterfield, because my brother is a vulnerable adult and he has a disability. Court, can you repeat those words for me? Satterfield, that my brother, he's a vulnerable adult and he's not able to function as a normal human being to deal with stuff like that. State, he's a vulnerable adult. Satterfield, yes. And that's from the transcript from the trial. This particular testimony had zero probative value as to Murdaugh's motive for the murders, and obviously high potential for unfair prejudice as it portrays Murdaugh as a man who preys on vulnerable victims. Personal side note, I think that's an accurate portrayal. However, the place is not in the murder case because it does not help the jury find the murder case. It does not further illuminate the financial crimes. It does not further illustrate motive. Much of the additional details the state presented as to Murdaugh's financial crimes had little or no probative value for the purpose of establishing Murdaugh's motives. It has to be sanitized because Murdaugh preying on his clients too much runs the risk of, yeah, then he probably murdered people. That's the problem. It does not point to motive. It points to character. And then it becomes more prejudicial than probative. They go on to say that the state's theory of motive centers on the point that his financial crimes were about to be exposed and that he needed time. The fact that he committed some of those crimes against a vulnerable adult adds nothing to the theory. To the extent many similar details may have had minimal probative value, that value is substantially outweighed by the unfair, prejudicial sympathy the jury was likely to feel toward the victim. By our calculation, the state spent a total of 12.5 hours of actual testimony before the jury over 10 days of trial to introduce evidence related to Murdaugh's financial crimes. And that becomes a separate trial. We are convinced the state could have effectively presented evidence to support its motive theory in a fraction of the time. Too much was allowed in, is what they're saying. By holding that the trial court in this case acted within its discretion in admitting some evidence of Murdaugh's financial crimes, we certainly do not intend to require the evidence be admitted on retrial. As is often the case, the facts and circumstances on retrial may be materially different from those presented in the initial trial. Thus, the trial court on remand must do as the trial court did here. Carefully and thoughtfully apply correct principles of law to the facts and circumstances before it. We do intend to require, however, that if the trial court decides to admit evidence of Murdaugh's financial crimes on retrial, the state must complete its introduction of that evidence efficiently without the lengthy presentation or inflammatory details with little to no probative value that was permitted in the first trial. Conclusion. As the Fourth Circuit declared, the Remmer presumption is alive and well. It serves to protect the right to a fair trial by an impartial jury for all defendants. Here, Hill, the former clerk of court, I injected that, egregiously attacked Murdaugh's credibility and his defense, thus triggering the presumption of prejudice, which the state was unable to rebut. As noted at the outset, Hill's shocking jury interference was accomplished outside the presence and knowledge of the outstanding trial judge and the superbly competent and professional counsel for the state and defense. Superb. Lots of flattery at the end of this ruling, isn't there? You're wonderful, Your Honor. Counsel is wonderful. Wonderful. Fuck that clerk. Everyone else is great. Fuck courthouse Becky. I mean, said like an appellate court. Well, said like a Supreme Court. Not said like EDB. Hill's shocking jury interference was accomplished outside the presence and knowledge of the outstanding trial judge and superbly competent and professional counsel for the state and defense. We are accordingly constrained to reverse the post-trial court's denial of Murdaugh's motion and remand for a new trial consistent with this opinion. Footnote 15. Footnote 15. We commend the post-trial court, which inherited Murdaugh's motion for new trial and was placed in the unenviable position of evaluating unprecedented jury interference by a clerk of court within the context of a murky area of law. And at the end, there is a note that is a nod to the Supreme Court's former Chief Justice Toll and a nod to the fact that the area of law in South Carolina until this decision was murky. We love you, Justice Toll. That's a we love you, Justice Toll footnote. Placed in the unenviable position of evaluating unprecedented jury interference within the context of a murky area of law. The fault in this is solely on Courthouse Becky. They complimented Justice Toll at least twice in this. They excoriated Courthouse Becky. They complimented the trial attorneys and the trial judge. And the question that I had gotten and saved earlier from Lucy was, is this binding or is this dicta? It's a great question. When we are talking about dicta, we are talking about things in a ruling that are not binding. Are we human or are we dancers, right? Or is it both the same? Is it dicta? As to the financial crimes, it's dicta. It is not binding. They say that it's not binding. It is caution. Danger. It is a unsolicited advice dicta. This is unsolicited advice. This is, hey, y'all, don't do that again. We can't tell you what to do. You don't have to do what we say. We can't tell you what to do. However, our unsolicited advice is be fucking cautious. So yes, that is dicta. It is non-binding. It does not order the trial court to do anything. It warns the trial court to not go so broad and so deep into the financial crimes. So it is a warning. It also says we're not finding that this evidence will be admissible again. It's not telling the court to do anything. So it is non-binding. Dicta. The rules you gotta file, dicta equals unsolicited advice, not Mike dicta. Unsolicited advice. What is the dicta? It's unsolicited advice. What the holding of this is that South Carolina is clarifying their position on the Remmer standard and adopting it loud and proud, and that Courthouse Becky fucked with this jury, and therefore Murdaugh gets a new trial. That's binding. And as this goes forward, if there is third-party, outside, external interference in a jury, this is the case law to follow. You follow the standards as they are laid out here. That's the binding part of this case. Ippy Fluffy, you said it way, I missed an opportunity. Ippy Fluffy, you did it way better than I did. Yes, Ippy Fluffy, dicta equals, that's my opinion.
That's my opinion!
100%. 100%. God, I missed the opportunity. My brain was still singing Sum 41. Okay. So where are we at the end of all of this? Alec Murdaugh is getting a new trial because Courthouse Becky interfered with this jury. And the South Carolina Supreme Court called it literally everything but a child of God. It was breathtaking, shocking, egregious, nefarious. They called the behavior of Courthouse Becky essentially one of the most appalling things that they have ever seen, an interference unknown to the South Carolina Supreme Court. They have never seen this level of interference with a jury. basically said, you have fucked around way too much. And remember, Courthouse Becky was prosecuted for perjury in that hearing with Justice Toll regarding the new trial motion and abuse of her position for a number of things, including stealing and the private tours. And she got probation and restitution. And it is going to cost the taxpayers of South Carolina millions to do this trial again. The question remains, will they do this trial again? And for that, we are going to take a look at what the Attorney General for South Carolina had to say yesterday, because we have a presser with Alan Wilson, who popped into this trial like one day and like asked one witness a couple of questions. I was like, what? Who the fuck is that? What is he? Where'd this new dude come from? The elected Attorney General. He's the elected Attorney General. I was very confused when that happened in trial. I was super confused. So we are going to go to Attorney General, who I think isn't he running for governor of South Carolina? We're going to go to his press conference, and then guess who else found a camera? Putin Jim. We're going to go to that next. Let's do this first. All right. Let me embiggen the screen. Oh, wait, hold on. I get to do this. We get to put up a bug. All right, there we go. Look at us. We're going to their press conference. This is from yesterday. And all of you want to know, is Creighton Waters going to be involved in this case? Well, there's Mr. Creighton Waters right there. Let's take a look at what they have to say. And if our closed captioning doesn't pop up, I'll go grab it.
Convictions of Alec Murdaugh.
There it is. It's really weird. So I found this on another news outlet. It started with him introducing Creighton Waters and then saying the South Carolina Supreme Court overturned the conviction, and then it jumped to this part. So we missed half a sentence. This one cuts in the middle of that sentence, but it has better sound. So we're going to stick with this one.
Ruled in a 5-0 decision to reverse the murder convictions for Alec Murdaugh for the June 2021 murder of Maggie and Paul Murdaugh. The court based its decision on the conduct of then Colleton County Clerk of Court Rebecca Hill. As you know, this conduct...
I keep trying with the Colleton County. Sometimes I get it right. Sometimes I get it wrong. Former Clerk of Court.
Involved her in interactions with the jury at that time. As the court said in the order, this was conduct unknown to the state and other individuals.
This level of fuckery we hath not seen ever. Yeah, it's like that.
Office's position has always been that the conduct, while inappropriate and should never be condoned, was ultimately harmless as it related to prejudicing Alec Murdaugh's right to a fair trial. The Supreme Court obviously disagreed in its conclusion. While we strongly disagree with the Supreme Court, we respect its decision because that's how the process is supposed to be played out. So now we must look to the future. What does this decision mean going forward for this office? First, Alec Murdaugh is currently serving a 27-year sentence for the financial crimes that he has admitted to in a guilty plea that we secured against him. And he has also waived his appeals for those financial charges. Additionally, he pled guilty to federal charges about 5 months after he pled to the state financial charges. He received a concurrent 40-year sentence in addition to the state's charges. So Alec Murdaugh will not be getting out of prison for several decades.
Which is good to know.
Currently, our office is reviewing the Supreme Court's order. We're meeting with members of our legal team and our staff. We're evaluating what our legal strategy will be going forward. As of right now, the state has 15 days to ask the state Supreme Court to reconsider its decision, and we have 90 days to appeal to the U.S. Supreme Court.
I don't think y'all want to do that.
However, it's currently my intention to see...
I don't think y'all want to do that. I think at the U.S. Supreme Court, this result doesn't change. I don't think this result changes. I think at this point, they've got to take a look at the precedent and the law and move forward, because this isn't going to change. There is no other court that's going to disagree. Excuse me. There's no other court that's going to disagree.
Has 15 days to ask the state Supreme Court to reconsider its decision, and we have 90 days to appeal to the U.S. Supreme Court.
That's not going to help.
However, it is currently my intention to seek a speedy retrial in the case against Alec Murdaugh.
And there's the answer to that.
Obviously, I always say this with the court's current decision. We obviously recognize that all defendants have the presumption of innocence unless and until they are proven guilty in a court of law, and Mr. Murdaugh will enjoy that presumption at this time.
Right.
Are there
now
any
we're
questions?
back to the beginning.
Mr. Attorney General, your opponents in the governor's race are jumping on this, saying your office bungled the case. I know the court's decision pointed the finger at Becky Hill, but are you worried that this is going to affect your campaign for governor and will look poorly upon your records?
No, not at all. Obviously, the court has been very clear. People who have known.
I think the court was incredibly clear that Becky Hill's behavior was unknown to the prosecution, unknown to the defense, and unknown to the court. So Creighton, though, does look like he's about to puke. Like, Creighton is seeing the rest of his career dealing with this Murdaugh case again. Creighton does not look happy. The court could not say strongly enough in polite context that Courthouse Becky fucked up.
Ever actually been a prosecutor, been in law enforcement, stepped foot in a court of law, held the hand of a victim as they got a jury sentence read, have ever gone through this process, they can make all the political haymakers they want out of this, but at the end of the day, people were murdered. People were murdered at the end of the day, and if people want to make this a political issue, that just shows their character or lack thereof. This office and the men and women who worked in this office at that time and who will be working on this case going forward are some of the finest prosecutors, finest investigators that I have ever met. Whether they're at SLED, whether they're in this office or other law enforcement agencies that we worked with, they did their.
I appreciate having the back of those that work in your state. However, coroner armpits was wild. Can we just agree that that was wild, please? Because that shit was really wild.
Jobs. The Supreme Court even said that in its order, that the state of South Carolina did its job right. Obviously, this court gave us some guidance going forward in the next trial regarding how they would like to see evidence handled, or presented, rather.
Less.
But they placed this squarely on the shoulders of the former Carlton County Clerk of Court. Anyone who says otherwise is purely playing politics with a very, very serious issue.
Attorney General Wilson,
I think that's fair.
Here or Walterboro, or do you know?
We would
Yeah, no, the defense is going to immediately ask this case to get kicked out of Walterboro. Immediately.
expect it would be in the same jurisdiction that it was originally tried.
Why? There were issues with the clerk of court in that court.
The clerk of court has been convicted of misconduct.
I mean, she pled guilty. Y'all should have gone harder, I think. But the clerk of court doesn't have any sway anymore. She's gone.
Playing politics
She
with a very,
gone.
very serious issue.
Attorney General Wilson, here or Walterboro, or do you know?
We would expect it would be in the same jurisdiction that it was originally tried.
Why?
The media, why?
There were issues with the clerk of court in that court.
The clerk of court has been convicted of misconduct and is no longer the clerk of court.
So you don't expect any other possible issues in Colton County?
Well, Carlton County is not the reason that the clerk of court did what she did.
The clerk of court did what she did because she did what she did. It had nothing to do with anything other than Becky. XOXO Becky Boo. That is a wild thing.
That was the clerk of court's decision.
Could she face any other charges as a result of this?
We're not going to comment on any.
That's the question the Lawnards would like to know too. Can she, sorry, that was the rudest pause face. Can she face any other charges? He's like, I'm not going to comment on that. I suspect that ship has sailed because the prosecution was aware of the juror misconduct and chose not to prosecute when prosecuting other things. They can't go back and prosecute her now for that.
Any other charges as a result of this?
We're not going to comment on any other possible. Obviously, the case against the former Carlton County Clerk of Court was referred to another solicitor for review. That solicitor made criminal decisions regarding the totality of her conduct. She pled guilty to misconduct charges with conduct unrelated to this case. I'm not going to speculate on anything else at this time.
Right.
Yes, sir.
Did this ruling come as
Because he doesn't
a
want to.
surprise, and what can you
Because he doesn't want to say there's nothing else we can do because it's awful. I get it, but that they cannot do. They were aware of it. They chose not to file it. That ship has sailed, and the ship's name is exactly what MTT said in the chat. There's our double jeopardy. Correct. You can't bring it again. Laura asked, what does speedy effectively mean here? This case starts back at the beginning. So because this case is now starting back at the very beginning, you now have a new right to speedy trial. And the prosecution's like, mount up and ride. What is it, 90 days more in South Carolina? So they're saying, we want a speedy trial. Let's go. New trial? Let's get the pretrial conference on the calendar. Bring them out. Bring them out. Let's go to trial. And I imagine they don't want to give the defense too much time to circle the wagons. They want this to go within the trial period.
tell to the people of South Carolina who might be worried about the cost of the second trial?
Well, first off.
Okay, first of all, I needed to highlight Carrie's comment in the chat. Carrie in the chat said, you mean what is double jeopardy? 10 out of 10. 10 out of 10 comment. 10 out of 10. And now the media is asking actually the questions we all want to hear. Because how much is this going to cost? Views through a lens, the defense can ask to waive speedy trial, but the prosecution also has a right to speedy trial. So the prosecution can put their foot down on delay just as well. And the courts tend to be more sensitive to it when we're looking at a retrial because there is a lot that can go wrong with a retrial. The longer you have, the worse it is for the prosecution. The prosecution also has a right to speedy trial. It is not exclusively a right to the defense. So hopefully that clarifies.
With conduct unrelated to this case, I'm not going to speculate on anything else at this time.
I want to listen to
Yes,
him
sir.
talk about the money.
This come as a surprise, and what can you tell to the people of South Carolina who might be worried about the cost of the second trial?
Well, first off, our office has always maintained, and we've never disputed, that the conduct Ms. Hill engaged in was inappropriate. We
This
have always
surprised no one.
maintained that the conduct was harmless error.
This surprised no one.
Obviously, if you, for those of you who watched the post-trial hearings, for those of you who saw everything unfold in real time,
Also
there
us.
were many, many, many witnesses who testified that
Us.
this, I think 11 of the jurors testified in open court during that post-trial hearing that they did not believe that this affected their decision. We believe that it was harmless error, and so obviously
The court
when the court came to a
disagrees.
different conclusion, it was obviously disappointing to me personally. I know it was disappointing to Creighton. It was disappointing to other
And the court didn't say it was harmless error. The court said that the state could not overcome the heavy presumption that this did not reasonably impact a single juror.
members of our team.
Of course, it's
And as far
disappointing.
as the cost of the second trial, for those who might
Money,
be
money,
concerned
money,
about
money.
the legal costs
Money.
incurred going forward with this, considering he is behind bars for several decades.
Here's the thing.
Sorry, I was singing over the question. What's the point of doing this again is what the media is asking.
Court came to a different conclusion. It was obviously disappointing to me personally. I know it was disappointing to Creighton. It was disappointing to other members of our team.
I backed up too far. Sorry, chat.
And as far as the cost of the second trial, for those who might be concerned about the legal costs incurred going forward with this, considering he is behind bars for several decades.
Here's the thing. When people are murdered, okay, when victims are murdered, they
You go
have
to
a
trial.
right to have their case adjudicated in court even though they're not currently here. Their family members who they left behind have a right. For those who want to see justice meted out, they have a right to that. So we're not going to let that be a factor in our decision to move forward. Seeking justice is the role of this office. Enforcing and defending the rule of law is the job of this office. It is the job of the men and women of this office, and that is what we have always held to.
Do you plan to prosecute the case any differently this time?
Oh, they're not
As I
going to
said
tell
a
you
moment
that.
ago, Mr. Waters and I have been in consultation all day. He's been talking with members of our team here in the State Grand Jury Prosecution Division. We don't want to comment.
Yes, they're going to prosecute the case differently. It is a different case. There are different considerations, but they are going to have to navigate the court's strong admonition regarding the financial crimes case. And Murdaugh's already been convicted of those. So that changes the landscape too. Yes, they are going to prosecute this case differently. They're going to have to. But I think the themes of the case will remain the same.
Publicly on what our legal strategy would be moving forward. Obviously, there will be very little surprises to the general public as this case gets retried again. But obviously, we have a roadmap the Supreme Court has given us based on what they have put forward in their order. But again, I don't want to talk too much openly about what our legal strategy would be because we haven't gotten there yet.
Was there ever any consideration of possibly taking this case up to the Supreme Court? You said you had a window to possibly get that done.
We're still in that window for 3 more months. So obviously it is something that we are contemplating all of our legal options and we're exploring everything. This just happened today. So making a firm decision one way or the other on what we want to do on.
Y'all, we all knew this was going to be the result, though. You can't tell me you haven't talked about it. It is a very politically appropriate answer. But you can't talk to me y'all haven't considered it because we knew that this was going to happen. We knew that this was going to happen. We knew that this was going to be the most likely result. There's no way they waited for this to come down and then say, what do we want to do, boys? The Supreme Court of the U.S. would come to the same conclusion. There's not really a point to going that direction.
On our right to appeal are things that we're going to be talking about in the hours and days to come, and we will be making those decisions. Regardless of that, it is my current intention to seek a speedy retrial of this case.
With the documentaries and the different podcasts that are already out, do you think that will taint anything in the case or the retrial?
I mean, look, you always are concerned about the exposure a high-profile case gets, and that is always something you're concerned about. But obviously, the process is designed and built to kind of cull that out. And obviously, I trust the process and the system to help us get back to a court of law where we can get this information back to a jury.
One more question. How quickly do you expect you could be back to trial with this?
What does speedy trial mean to you? What are we talking about? Are we talking about fall? Are we talking about fall? When are we clearing our calendar for this trial? How speedy are we talking?
My intention, and we've talked about this, it's aspirational, but we would like to try to get back before the end of the calendar year.
What?
You might not.
Before the end of the calendar year. So 6-7 months? Shit. But also 6-7. Okay. That is aspirational. I guess, will we see a Murdaugh trial before the end of 2026, or are we going to see it in 2027? Is it going to be in 6-7 months, or is it going to be 26, 27? Damn it, too much 6-7. But also, we all doing this for Thanksgiving? What are we doing? What are we doing? You heard it from the AG. They would like to do this before the end of the calendar year. Nameless musician in the chat said Murdaugh 2.0 before GTA 6. Probably.
The Attorney General by that point.
Wow.
Irrelevant. It doesn't matter who the Attorney General is. The Office of the Attorney General will still be here. Would I like to be involved in this case like I was the first time? Absolutely. But like I said,
I'd like to be the governor too,
many of the
apparently.
men and women who were on that original trial team are still in this office. Some have obviously moved on to other opportunities, but most are still here. This office is still going to be here long after Alan Wilson leaves it. So the decision on whether or not to pursue this case is not going to be built on who the next occupant of my office is.
It's going to happen now.
On should we seek justice or not, and we're going to seek justice. I'll take another question or two, then we have to run.
Retrial.
I guess, Attorney General, there's been calls for reform of the system. You yourself have called for judicial reform. Given that the finger's been pointed at the clerk, are there any reforms you think should happen for clerk?
Yeah. This is kind of a one-off, though. The fact that this has never come up in the history of the state indicates that this is kind of a one-off, though. It's kind of a one-off, though. Because, damn. But the media is asking, should there be reforms with the clerk of court? I mean, I would have liked them to throw the book at her, but they chose not to do that.
Within the judicial system.
Look, the system worked when it came to the former clerk of Colleton County.
They figured it out.
Obviously, after the fact, unknown to us, as the court said in its order, her conduct was obviously made known. That was handled by the system. Other conduct that she engaged in, which was discovered long after the trial concluded, that ultimately led to her conviction for misconduct in office.
I mean, you can limit their ability to write books. And that went up to the ethics board because it's also against the ethical rules. So it went up to the ethics board, but it got published before they did anything. So yeah, there are rules about that. She just didn't give a fuck. Because she's so special, you guys. She's Courthouse Becky. She's Beckaboo. XOXO. It's all good. She excels at everything that she does.
Was handled by another solicitor's office that I signed them that case, and that was handled appropriately, and she was convicted in a court of law. So the system addressed that individual.
I mean, she
I
pled.
know you're not going to speak about your strategy, but do you think the evidence that they pointed out that you spent too much time on the financial woes of Murdaugh, do you think that's going to have an impact on your trial going forward?
I mean, look, we have the benefit of hindsight now.
Oh, good. Creighton did blink.
We believed, and the court did say in its order
still.
that the evidence that we got in was permissible. They obviously provided us some guardrails to go back on remand to the original trial court where it will be tried, and they gave some guidelines and some guidance that we will obviously evaluate and use
admonition
as a guide in presenting the next case. I'm happy, Creighton, if you want to take a moment, I'm happy to let you address that issue as well.
Yeah, I mean, absolutely. We, of course, were...
Creighton it's so funny to me. Creighton is such a trial attorney. Doesn't need to step in front of the mic. Creighton's like, y'all are going to hear me just fine. I don't think I could ever stand that still at a press conference. But Creighton's like, yeah, you can hear me just fine.
Aggressive about that evidence, but as you recall, we filed multiple pretrial briefs. We laid out our theory of the case. We put all that evidence on the table, and ultimately Judge Newman heard it all and agreed that it was permissible. But this is part of the process. The Supreme Court multiple times in the order said that this was viable evidence of motive, but ultimately gave us some guidance about the extent. That's how it works.
They called it a bit.
You don't hit a home run if you're afraid to strike out. And so as a prosecutor, you have to deal with double jeopardy. We had a viable reason for putting in this evidence, and so we did so. Ultimately, the court, as the AG said, ruled on Becky Hill, and then they said, while we're at it, hey, this is permissible evidence, but let's put some guardrails in place. That's just part of the process. They also, though, multiple times in the order talked about I think they called superbly competent and professional presentation by both the state and the defense. So
they did
these
say
things
superb.
are not 2 + 2 = 4.
Say it again.
Superb. And we did our job. We still believe that the case should have been affirmed, but we recognize the court's reversal, and now we're going to go do it again. That's the plan.
We're going to go do it again.
Back to January, in which arguments were brought before the state Supreme Court, was it a difficult or untenuous position to have to, in some ways,
defend
talk about Becky Hill?
Becky's
and
bullshit.
Basically, in some ways, make sure that, to say it no other way, to kind of defend her in that hearing?
Yeah.
Well, again, whenever you try a case and you, as a prosecutor, like I mentioned, with double jeopardy, you have to, within your interpretation of the rules, be aggressive. And so we were expecting that. The one thing you don't expect is to ultimately have to address these issues with the clerk. As we presented to the court,
Yeah,
and
she
as
went
the agent
rogue.
just said, we thought that Justice Toll got it right, that ultimately there was no effect on this verdict after 6 weeks of trial and all the evidence that was presented. Supreme Court saw it differently, and that's their prerogative to do so. So certainly that was not an issue that we were hoping for and expecting, and unfortunately that was the one where the Supreme Court hung its hat. But again, that's part of the process. You dust yourself off, you get back up, you take a fresh look at it, and then you go do your job. And that's what we plan to do.
There is, I can't imagine anything more frustrating than things outside your control as a prosecutor fucking over your case. If it's your decision and you made a bad call, you have to live with it. That was your decision. That was your call. But when it is completely so far out of left field, so far out of your control, the rage that someone else undermined your case, woo! The level of anger. The level of anger.
I want to close by first off just thanking the team in the Attorney General's office. Obviously, we're disappointed, but I couldn't be prouder of the job that Creighton and his team did. We lived through 6 long weeks 3 years ago, and
yes,
we believe we did a good job for the
did.
people of South Carolina. We believe we represented the criminal justice system very well. A lot of people didn't think we could get a conviction, and we got it. Unfortunately, someone, unbeknownst to us, engaged in conduct that the Supreme Court believed prejudiced a defendant's right to a fair trial, and the Supreme Court made the decision. While we don't agree with that decision, we respect that decision, and we're going to comply with that decision, and we're going to follow the rules given to us by the court,
jury.
And we're going to move forward. Again, we will keep you all up to date as much as we possibly can on all the developments that come out. Obviously, we have a lot of work to do. We have to reevaluate. We have to review. We have to meet with people and make decisions.
You got to figure out somebody else that's not throwing a phone around their office. That's not going to work. You got to do a different expert on that shit. That needs some explanation. The phone being hurled out the window needs some more explanation. And you've really, really got to evaluate what is going on with Murdaugh's car, because that came in the middle of the trial, and that needs some evaluation and thought as well.
In the coming weeks, again, our hope is to get this case retried by the end of the year, but obviously, time will tell if we're able to do that. But that is our intention at this time. I want to thank all of you for giving us the opportunity. I'm sorry it was late in the day, but we had to absorb everything. We had to meet with a number of people, and we wanted to be able to give.
Tell me about it. This is the first thing I saw as I was trying to get ready to do the Richens sentencing, and I was like, today, of all days, today, we're doing this today?
Give you this information as quickly as we possibly could. So thank you so much. I hope you have a wonderful day.
All right, everybody. You heard it from the Attorney Generals. Murdaugh Part 2 before the end of 2026. I'm real curious what the first date on calendar is going to be for this. I'm going to keep an eye on it. But that's not all. Because, well, it wouldn't be the Murdaugh case without a statement from Dick and Jim, who this morning were on the Today Show. So we're going to take a look at what Dick and Jim had to say on the Today Show this morning. That might answer some of the questions that you all have had for me. Let me get that pulled up, because y'all had some questions. I'm curious to see if Dick and Jim respond to those questions. So let's take a look at what the defense had to say this morning, because I have so many questions. Amelia, is there Do you think there's any way the defense could legally get Creighton taken off the case? No. I mean, they would have to disqualify the entire state attorney general's office, which would be really tough to do. But they're going to make a change of venue motion, but Creighton would just go with it. They're the state's attorney generals. It's not like if you move from one county to the other, the attorney doesn't go with it. I don't think there's any grounds that they could take Creighton off the case. I haven't seen anything that would point to a Creighton problem. All right. Well, I like Jim's bow tie, poots in purple. I guess we're off to a good start.
Gentlemen, good morning. Thanks for being here.
Good morning, Craig.
I know that you talked to Alec yesterday. What was your client's response to the decision?
Immediately into attorney-client privileged information. Hey, what did your client say? And they're more than happy to share it.
Yeah, Craig, we had told him that the argument went very, very well. We were very hopeful in the result. He didn't believe that it could be possible. And then yesterday, he was very gracious, thankful.
This is from this morning.
And he said, Jim, I'm seeing, I'm reading it, and it's still hard to believe. But he's glad to get that moniker off of him as a convicted murderer of his wife and son. No doubt about that.
Dick, you said...
We're going to start seeing defamation lawsuits, Jim, if people are calling him a murderer. Is that where we're going with that? He's happy to get that moniker off of him as a convicted murderer because that conviction has been overturned. He is not a convicted murderer. He is now back to charged with the murder of his wife and son and awaiting trial for the murder of his wife and son. We're back to the presumption of innocence. I don't think that's going to change the public's mind again. You can't really doodly boop that. But I'm sure he's thrilled.
A few months ago when you were here, you said that you were confident that he would have, quote, a fair shot at acquittal if there was a retrial. What makes both of you so confident?
Well, I think that everyone says, well, the jury convicted him so quickly, evidence was overwhelming. If you take away all those financial crime, prejudicial, victims testifying, the Supreme Court talked about that yesterday. You've got no forensic evidence, no fingerprints, no eyewitness, no confession, no video. The only thing they have is this. He lied about where he was.
The Snapchat video.
Not
Right.
the only thing.
The motive is paper thin, and maybe it's better to understand what they don't have. That's why they went all in on that financial crime stuff. And of course, we know this jury was lobbied.
I love that they're using Bubba in the background. I love that they're using Bubba
by the clerk of court to convict. So I think a retrial is going to result with a fair jury. I think gives him a chance for acquittal.
I remember.
To be fair, every trial gives a defendant a chance for acquittal. Every trial. Whoever does the flowers on the Today Show, by the way, I very much enjoyed that flower arrangement. But yes, every trial gives a defendant a chance of acquittal. They have a presumption of innocence. Mm-hmm.
Several years ago, you both talked about this investigation that you were starting to coincide with the actual law enforcement investigation. This investigation, I assume, has been going on for several years now. Has it yielded any new leads? Is there a new...
That's a really good question. Y'all were looking for the real killer. Y'all were looking for the real killer, remember? Did you start that investigation? Has that investigation rendered anything fruitful? Look at the look between the two of them. What a great question. What a great question. Y'all found the killer yet? Y'all solved this case yet? Look at their faces. What a great question. What has that investigation turned up, y'all? It's been 3 years. Look at Poot's face. How's that investigation going, guys?
Working theory about if it was not Alec, who it could have been?
We do have information that's been provided to us.
Since the trial.
Since the trial. And there frankly, a lot of people out there who believe in Alec's innocence, who continue to work and provide us information. But
what kind of information?
Well,
that's a good question.
Potential third parties and potential motive.
That's not an answer. I like the questions, though. Those are some good pointed questions. Look at this. some good pointed questions. Hey, where's that going? Well, we have some thoughts. We're workshopping it. That's not an answer at all.
And we can't disclose it here right now and don't intend to.
Can you characterize the nature of it? I mean, are we talking text messages? Are we talking?
I can't characterize the nature of it, Craig.
Stuff.
And by the way, I wish we could talk about it, but
Poot's like, Jim, hold on. You haven't politicked this well enough, Jim. Let me step in. I sure do wish we could talk about that. I sure do wish we could talk about that, but yeah, we're just gonna have to wait. Poot's like, let me politic that for you, buddy. Let's just clean that up a little. I sure wish we could tell you.
I think this reversal is going to give us much more access to that information. Either these folks.
So you don't have any information. You don't have any information? It's going to give us more access to the information. So we haven't done anything then. Right.
And by the way, I wish we could talk about it, but I think this reversal is going to give us much more access to that information. Either these folks that were hesitant to tell everything will come forward and tell us that, but more importantly, we now have the power of subpoena. We have the power to investigate this using the legal process.
So no. The answer is no, there's not an investigation. The answer is that they were investigating. It actually would have sat better for me, and who am I to criticize? I'm just sitting here watching it, but it would have sat differently for me if they said, we have put all of our energy into the South Carolina Supreme Court. And that has been our focus. And now we are very happy to be able to shift focus back and use the power of the court to shift that focus back. Versus, we got subpoenas now, so we're gonna start looking. We're gonna start looking now.
The reality is he's still going to spend a few decades in prison on the financial crimes.
Absolutely.
Is there a school of thought in which either of you think that a jury might be more willing to not convict him this time around, knowing that he is going to spend 20, 25 years in prison?
Jim?
No.
I mean,
they won't know that.
Adhere to that school of thought. I mean, frankly,
the jury won't know.
It will not technically, legally be before a jury. I mean, they won't know, but, you know, as a practical matter, in the back of their mind, they probably.
The jury won't know that he's doing time. The jury won't know that he's serving time on the other cases or how much. They shouldn't. So, yeah, and I don't think jurors are going to be like, oh, no, he's been convicted on financial crimes. Let's let him go for murder.
Will, and so, but I will tell you this, on a retrial, the statistics are in the favor of a defendant because you have a lot more recorded testimony of witnesses. You get to impeach them with inconsistencies, and so they're
memories fade, witnesses die. Yeah, retrials are not always easy, though. A lot of those retrials are based on a trial after a hung jury. A lot of those statistics are retrials after a hung jury.
It'll be a totally different trial, I promise you.
A number of the jurors after the trial said that they thought Alec taking the stand was a mistake, that it hurt him.
I think they said it sitting on that couch on the Today Show that they thought Alec testifying hurt him. I think they did.
If in a retrial, does he take the stand again?
Well, everybody misunderstands. We don't tell a defendant to take the stand or not. We give them advice, especially when you're a client as a lawyer. They're going to.
Yeah, I don't think they told Alec what he was going to do or not. I think Alec was telling them exactly what he was going to do. Poot's right about that. It's Alec's decision if he's going to testify or not. You know, honestly, chat, I think he has to testify again because that's really the most entertaining outcome for me. Legally, do I think that's a sound cause? Well, you know, I think he's been a lawyer just about as long as I have, if not longer. Oh, no. When did he get disbarred? I would have to check the dates to see when he got disbarred. But I think he's been a lawyer longer than I have, at least by a bit. And he can make that decision for himself. But yeah, EDB says, go for it. Go for it. Be super curious. Soup's curious what you have to say.
Make that independent judgment. So the guy that can answer that question isn't here this morning.
But I do want to point
No,
this
he's in
out.
prison.
That jury was tampered with. That jury was told, don't believe Alec before he got on the stand in so many words.
a fair point,
and so
Jim.
The jurors came out saying, we didn't believe him, but they were coached to...
Jim, better answer than Poot. That's a good answer. Good answer, Jim. That jury didn't believe him because they were coached. Because they were coached. Right. Right. Cam said, if you get disbarred, you don't instantly forget how to be a lawyer. No, I was being snarky that Alec's years of a lawyer are not continuing to rack up because he was disbarred. So he got frozen with how many years he was a lawyer in good standing. My years as a lawyer of good standing continue to tick. So I will at some point surpass him. So I was being snarky about how long I've been a lawyer versus how long he's been a lawyer. I think he's about 10 years older than I am. So he's got a little bit of time on me, but then he did get disbarred. So, we'll be able to catch up.
not believe him. And as the Supreme Court said, Becky Hill put her finger on the scale of justice and impacted the result of that trial.
The state has indicated they want to retry him quickly. If there's an about face and the state says, we're willing to offer a plea deal, we don't want to go through this again. We want to save the taxpayers some
no plea.
Wow. You're not going to take a plea under
no.
any circumstances.
Under any circumstances.
He will never plead.
Never plead guilty.
Killing his wife and son, I promise you.
Never.
Why not?
Because he didn't.
Did you see how fast they answered that? Look at the hard-hitting questions coming out on the Today Show. If they offered a plea, what's he going to do? Immediately no. Immediately no. Immediately no. Damn, they answered that fast. But also, I believe that's 100% the truth.
Save the taxpayers some.
No plea.
You're not going to take a plea under any circumstances.
Under any circumstances.
He will never plead.
Never plead guilty.
Killing his wife and son, I promise you.
Never.
Why not?
Because he didn't do it. How about that?
And you remain convinced of that?
I remain convinced there's no evidence that he did.
Poot. Poot's been a politician a long time, y'all. A long time. Do you remain convinced that he didn't? There's no evidence that he did. Poot. I'm not mad. Honestly, I'm not mad at that answer. Those are the answers I kind of expected from Corey Richard's team yesterday, and they got all weird. Like, that shit was so weird yesterday. It was so uncomfortable, where the lawyers are like, I believe the vouching and the personal statements, and the only God can judge me of it all. Poot is kind of what I expect for a lawyer, right? This is what I expect. There's no evidence that he did. I'm not giving you my personal thoughts on it. I'm telling you about the case.
Remain convinced of that.
I remain convinced there's no evidence that he did. Okay?
How is the approach going to be different this time?
Oh, Poot.
Well, I don't know that we ought to go into details on that, but because somebody, Alan Wilson, may be watching this.
The Attorney General of Really quickly, this is always a question
We don't know yet. We're going to figure out what we're going to do, and we're definitely not going to tell you. I don't think we should tell him. No, I don't think we should tell him yet either. We'll figure it out.
I've wondered, you may not ask, but I'm still going to ask, who pays you guys? I mean, this has been going on for several years now. He allegedly...
Damn! I love this so much. Who pays you? That's what we want to know. Craig came prepared. Craig's got the questions. Look, Craig is asking what the law nerds want to know. Get it? I am living. Asking the questions we want to know, even if they're not going to answer them. Who's paying y'all?
Still going to ask, who pays you guys? I mean, this has been going on for several years now. He allegedly has no money. How are you guys being compensated?
I'm going to defer to Jim on this because this is a discussion he and I have all the time.
Yeah. So, is it pro bono?
Poot's like, this is a discussion we have all the time. I wonder if Poot's like, hey, Jim, we done here, my guy? How are we getting paid? Who's paying me? How are we getting paid? Poot's like, Jim can go ahead and answer this one. Oh, boy. Great questions.
Craig, we got paid to try the first case.
Okay.
And there's no more money left. But when you do this work, you represent a criminal defendant. I mean, it's like you got paid for a job, and the job's not done. So, it's a loss leader right now. We're doing it. We're not getting paid, but we're going to see it through.
And we're looking for avenues to perhaps get some money for
taxpayers of South Carolina. How you doing? How you doing? We're going to need some money. Oh boy. Oh boy. So they're not getting paid for trial number 2.
Expert, not for us, but for expert witnesses.
Yeah.
I mean, the costs in the first trial were $600,000.
Dig, Jim, I wish we had more time, but thank you. Thanks for making
the costs were $600,000. Costs, experts, etc. That money's got to come from somewhere if you're going to bring in your experts. Or Murdaugh's going to, I don't know if you can have a halvesies with private counsel and the public defender's office. It's going to be real interesting because we're going to see those motions happening. We're going to see those motions happening at the beginning of this case. Motion for change of venue, motion for costs. Going to be interesting. Can he get a public defender? He sure can. He sure would qualify. I don't know if he can have these lawyers and a public defender is the question. So, going to be real interesting to see what happens there. Who knows? Maybe they'll sue Becky Hill for her lake house. Oh, wait, she doesn't have one. Maybe they'll sue Becky Hill and be like, look, now we got to pay for a whole new trial. That's the harm to us. Though there are avenues for Murdaugh. There are avenues for Murdaugh, but that was a good interview. Let's see if there's anything else.
Well, thank you for inviting us.
We're going to have more on this case.
All right. Sounds like they are done. Well. We learned quite a bit from the press conferences, didn't we? Current Attorney General of South Carolina, Alan Wilson, said that they are seeking a speedy retrial and that they hope, though that hope is ambitious, they hope that they will retry Murdaugh before the end of 2026. That would be incredibly fast. I guess we'll see what happens. The first trial did go to trial within a very quick and short period of time. So maybe we will see this one also moving towards a speedy trial. That was a great interview with the defense as well from the Today Show, asking the questions that we actually wanted the answers to, which was fantastic. Hey, how are you guys getting paid? Murdaugh's broke. And Jim and Poot said that they got paid for the first trial and that there's no money left, and they're going to be looking at ways to get money for the expert witnesses. I imagine we'll see motions in court about that. We also saw a lot of questions about what's the strategy now for both sets of attorneys, and everybody was like, we're not going to talk about that. And where do you go from here? And from both sides at these press conferences, both sides said, where we go from here is to trial. There is no plea. There is no conversation. There is no dropping this case. We are going to trial. And when asked, Poot and Jim swiftly said that Alec Murdaugh would never plead to this. And when asked again, Poot's like, well, because he didn't do it. How about that? And then it's like, so you believe he didn't do it? I believe there's no evidence showing that he did. Poot! Very interesting answers from both attorneys, but this case is bound for trial. There's going to be a lot of motions on the road forward to trial number 2, but Murdaugh trial number 2 is going to be an adventure. So I guess Murdaugh's back on the docket full time because there's going to have to be an initial appearance to start setting this case. And we're going to get into those motions for change of venue. I imagine the defense is going to have to bring motions to get some money for experts. And we're going to start the trial process all over again. So, Murdaugh trial 2. it's a retrial, but it's not a retrial in the sense of a hung jury, but it is a retrial. I think it's second trial more appropriately than retrial, but Murdaugh trial number 2, here we go. Let's, we're going to
bring the jury.
I'm going to misjudge Newman. I'm going to misjudge Newman. But I'm interested to see what we get out of this trial and how much involvement will we see from Poot, from Jim. I like Attorney Barber quite a lot. If we will see him handling more of this trial, I thought he was incredibly effective for the defense. I personally would like to see more from Attorney Barber. Attorney Barber didn't come across to me as much as part of like Alec Murdaugh's clique. It didn't feel as personal. It didn't feel as much as like, this is me representing my friend. And there were times where that was an uncomfortable tension in Murdaugh trial number 1. I think that we will see Creighton Waters being the lead for the state again. And I'm curious to see what grouping of attorneys we get and whether we have Jim Metters standing back up next to the witnesses, looking over their shoulder, being like, so what about that down there? And kept getting told to get back to counsel table. He was just like cozied up next to the witness stand being like, and what about this over here? Jim Metters was just like identical. Wild, absolutely wild. So will we see Metters back on this prosecution team, given a fire and brimstone rebuttal or not? Either way, there's going to be a Murdaugh trial number 2. I did not expect that we would get there. I guess I'll believe it when I see it, but Murdaugh's back on the docket, y'all. And we're going to be spending more time in the lovely state of South Carolina. I enjoy Charleston, y'all. I do. I enjoy Charleston. So let's get to a few questions. And then EDB's got to go. My kids are home. We got stuff to do. So trial number 2 is happening. When is it happening? We'll see. But let's have a quick little chat. Let's get to some questions. It's been a busy week, y'all. I am exhausted. That was way too loud, chat. I am so sorry. Chat, I'm sorry. That was my fault. I know a lot of you are asking for a supercut of the Murdaugh trial. I will talk to the team. I mean, that's a 6-week trial. It's going to have to be a couple supercuts. It will. It'll have to be a couple supercuts because it was a 6-week trial. It was a 6-week trial. Sorry for how loud that was. My apologies. I didn't switch it. I am Ken Ross says Vineyard Vines needs to capitalize on this opportunity. I'm ready to buy that blue shirt. I mean, you're ready to dress for this trial. I can't believe we're going to be back in South Carolina. But there we are. Sue, thank you so much. Sue with her member chat said, don't worry, Joe. You're a superb manager. Say it again. Superb. I love it. I love that we're all on the same page. We get to hear EDB say Creighton. That tickled me so much last night. Creighton, what are we doing? There were times, but there were also times that when the full like trial dog came out, you were just like, damn, Creighton, let's go. Also, maybe we'll get to hear more about Creighton's band. He plays guitar, he sings. It's going to be so much. Espresso. What's up? EDB, can he plead guilty and not do another trial? I mean, everybody would have to be on board to that. And it sounds like nobody's on board with that. It sounds like trial is going to be trial. Morgan, you and so many others asked about double jeopardy. No. The case being thrown out starts us back at the beginning. So it is not double jeopardy. Now with Courthouse Becky, because she was not charged and they could have charged her, that could implicate double jeopardy. But for Murdaugh, his first trial being thrown out, same as if a jury hangs, the first trial is not concluded. So we are back at the beginning of a trial. Sarah in the chat asks, will it be the same judge? Nope. He retired. And I do not see Judge Newman coming out of retirement for this circus. I think Judge Newman is going to be sipping some sweet tea, watching this all unfold and being glad he's not a part of it, because it's a lot. Thank you, everyone who gifted memberships for the gifted memberships. Emily, is this the first whole ass retrial we will watch? No. Karen Reed. We did 2 Reed cases. It is not our first retrial. And it's not our first trial. Well, it's going to be in front of a different judge. Not our first retrial, though. Retrials still give me a little bit of twitches. There was a lot of my life as a DA that there was one particular trial that was retrying. And talk about trying. It is trying to retry cases. And things can change quite a lot. It will be really interesting to see how this case changes and what happens on the retrial. It's going to be really interesting. Marls says, I'm not sure I'm ready for this deja vu. How will they ever find a jury? I think the defense is going to bring that up, and they are going to make a motion for change of venue. But in every case, we have seen the ability to find a jury no matter how high profile. It might need to change venue, but we have. Kennedy's Mama 22, thank you so much for the super chat. Emily, thank you for giving me a sense of belonging. I love this community. As a stay-at-home mom, your lives give me a community. Thankful for you and all my fellow Lawnards. We're happy to have you here, Kennedy. I love this community, and you absolutely belong here. The Lawnards are such an incredible community. I love being here with y'all every day. Some days I'm dumbfounded by what we're watching together, but I'm always here to watch it with you because this has been wild. Aurora Aura said, I can't wait to see if Poot has taken a gun safety course in the courtroom. One of the wildest moments. I think I rewound that. I rewound that so many times. Because it was so much. Danger Kitty, congratulations. Danger Kitty said, my kiddo got guard captain 6'7". I'm so proud. Congratulations, as you should be. It's an incredible thing. Shelly, happy 60th birthday. Sorry that it's Murdaugh New Trial Day, or yay, Murdaugh New Trial Day. There were some delightful things about the Murdaugh trial. Truly some delightful things. Julie B said, I'm 39 weeks pregnant, Emily. Don't start with the feels. I'm trying to rein them in as best I can. They just keep cropping up. It's going to be that way for the next few weeks. Yeah, it's just going to be all the things. Let's see. Mandy Me said, I let my son skip school to watch Murdaugh testify. Those are educational experiences where you don't want to miss the moment, because it was quite a moment. Also, I think quite a bit of my high school experience was popping in and out of classrooms watching the O.J. Simpson trial, because watching trial is always an educational experience. So we'll see. Hopefully now the prosecution will have enough time to get all of the data from the car companies. That was ridiculous the first time around. Yeah, it was. It was absolutely ridiculous, and I hope that they have more information on that. I definitely remember Poot with the waving the gun around in the courtroom, looking at the prosecutors and saying, tempting. And everybody just kind of laughed. And I was like, what are we doing? What are we doing with that? So it's going to be a trial. Emily said, I love legal poetry. Do I have to get a job as a paralegal to write poetic legal filings? I mean, or you could work for the judges. There's options. But yes, the poetry of that, gosh, South Carolina brought the sassy footnotes and the shade and the drama and the vocabulary. Loved it. I hate the result. It is the right result. And this is the hard thing with law, is it is really difficult to look at something and go, this is the right result. I hate this result. It's hard. But that is something that is known under the law. This is the right result. I hate this result. This is the right result. Alec Murdaugh should have a new trial. What Becky did was abhorrent and should never have been done. And the court got it right. The court updating the law gets it right. Protecting people from overreach gets it right. And if the state can prove this case, then they'll be able to prove it again. And if the state can't prove this case, then it proves why a new trial was needed. So it's correct, even though it's frustrating. It's correct. And that's hard. Ashley asked, EDB, do you think they'll have to rehash as much of the financial crimes again to make their case in chief? Ashley, I'm glad we saved this till after we finish the opinion. They will not be able to. They are going to have to wait, or they are going to have to pare that down. That's what I mean. Matt Davidson, realtor, who typically pays for the cost of a retrial like this? The taxpayers. Yeah, the taxpayers do. Though could Courthouse Becky be sued by the taxpayers would be a really interesting question. Really interesting question. Because it absolutely squanders the taxpayer funds. Then again, the other option on that is that the taxpayers are always going to be paying for another trial anyway. But yeah, I would love to see Courthouse Becky held a little bit more responsibly. I also hope that as the media covers this, they cover the legal aspects of this and make sure to focus on the legal aspects of this. So let's see. Hedgehog in Space says, EDB, will you represent me, a taxpayer suing Becky? I will cover it vociferously. But I am not barred in South Carolina, and I want to watch that lawsuit happen, but not from inside the courtroom. I want to do it from here. So, let me know. I'm curious to see what happens. Tanny says, Snapchat was not great, but the lack of blood evidence in such a horrendous scene was bigger. The phone evidence was shoddy, especially with the expert tossing it, which is a fair point. This is a very circumstantial case. And the retrial will be interesting. It will be interesting. Retrials are not guaranteed to come out with the same result. They're not. Tina, thank you so much for the 20 gifted memberships. Dom's mom said, EDB, green is a great color on you. I have realized that my coloring, especially when I am under our lights, does a lot better with green than my favorite color, black. I love green. So we will be seeing more green on EDB. I love green a lot. Also, it works very well when I am on the road with my kiddo. Any plans for I'm with the band in a tank? I'd get one yesterday. We are evaluating what to do with merch because a lot of you have requested merch. We are evaluating. Do I have any plans at this very moment? No. However, I have heard you. We do have the tanks that we have in stock, but not very many tanks left. But I've heard you guys ask for them. We were supposed to have a different tank in this launch, and it got held in contempt. So we had a plan for 2 tanks, and it got held in contempt. So, Domsman, do you think Murdaugh could have won a retrial without the Becky shenanigans based on the financial stuff? Oof. I don't know if they would have overturned on the financial stuff alone. They were not happy with it. It's possible. I do not know if it's probable, but it's possible. Yeah, it's possible. So I guess we'll see, but it's possible that they could have. Brittany says, so Murdaugh is now case law. Murdaugh is now case law. And this is going to be used in cases in the future. Stephanie said, EDB, do you think they thought the Today Show would be a softball? Probably. And look, they can handle the questions, but I appreciate that it was actually questions I wanted to hear the answer to, not just like rah, Murdaugh. It was actual questions like, would he plea? What are we doing differently? What's the strategy? How did he react? How are you getting paid? This shit's expensive. I appreciated the questions. They were the questions I wanted to hear answered too. Love it. Tanya said, so excited to be here with you, EDB. Tomorrow is my 40th. Happy birthday. 40s are fabulous. Daughter's junior prom is Saturday. Got all the feels today, but my swag will be here Monday. Congratulations. Enjoy prom. Remind them that they will never regret the pictures that they take. They will only regret the pictures that they didn't take. So if your kids are like mine, it's just like, let me do 3 pictures. My kids do not love letting mom take a picture. Let me do 3 pictures. We will not regret the pictures that we have. And then I have to do it very quickly. Very, very quickly. Music to My Soul said, will some of the element of surprise in how the state presented and argued the Snapchat footage in the first trial be lost? Oh, absolutely. However, I think the defense, there really shouldn't be anything surprising to trial lawyers because you have all the evidence in advance and the arguments that can be made from it are limited by the bounds of your own creativity or limited by the bounds of your own perception of your case. You should, with all the evidence, be able to foresee what the other side is going to argue and how they are going to bring it up. Nothing should be new, shocking, or surprising. Sometimes on rebuttal, you get some things that are surprising, but those are things that are surprises to the prosecution too. So they should have been able to foresee it, but yeah, it's going to be a lot of the same arguments. You're not going to see the Commonwealth completely shift tactics. Wait, no, the state. We're not going to see the state completely shift tactics here. So let's see. Brandy Carr said, I hope it isn't 6 weeks again. I don't think it will be. We're going to cut down a lot of that evidence. And remember, some of the length of the trial was that 8 witnesses had their entire testimony done twice. Because they did it outside the presence of the jury and then with the jury. That's a lot of back and forth. Lyndon, this is an excellent point. The car data coming in mid-trial was wild. And they have more time to prepare for that. I think that helped Murdaugh more than the prosecution. True. I think that helped him more. Lawnards, I know we did not get to every single super chat. I am going to go catch up with the kiddos in the limited time Travis is still home because the Cavaliers, his DCI corps, post every single day their countdown to training camp, and we are under 10 days. So I am going to try not to keep counting those days, even though it keeps popping up everywhere because they are just counting down to spring camp. I will see you guys briefly next week. If you do not have the Lawnard app, now is the time to get the Lawnard app because it will keep you in the loop with the scheduling bumps that we are going to have because we have some scheduling bumps coming up, and it will keep you in the loop with breaking information as it happens, like I sent out yesterday with regard to Murdaugh before we got into court on Richens. But I will not be streaming every single day next week because I will be doing all of the high school graduation things. So Lawnards, make sure you get the Lawnard app. There are a few things from the I'm With the Band launch that are still available in the shop. Numbers are limited. The lanyard with our VIP design and our VIP tag, words are escaping me at the moment, but there is a surprise on the back that I think you will very much love if you get that. So if you have that coming in the mail, don't forget to check out what is on the back of our VIP badges. And we are almost sold out of our launch. So if there is something that you were interested in, today is the day. Now is the time. I will see you guys briefly next week. We will have a podcast for you on Monday. I would love to let you know when I'm recording that. I do not know yet, Lawnards, but I will keep you posted on that. And I have got to scoot because Travis also has a performance this evening. So I have got to zoom. Lawnards, you are the best. I will see you soon. Thank you for being here. Thank you for being a Lawnard. Take care of yourselves. Take care of each other. And I will see you very soon. Lawnards, you're the best. Love being here with y'all. Have a good one. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnard app at lawnardapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Lawnard.